Letting the public in, recording, making Ava the host. If you can make me the co-host, Ava.
Of course.
And you are good to go.
Thank you. Good afternoon. I am Senator Martha Hennessy from District 5 and the chair of the Senate Judiciary Committee. Today we'll be hearing a wide variety of bills from the Judiciary Committee. And before we get started, I would like to read a checklist to ensure that the meeting that we're holding is in compliance with the right to know law. As chair of Senate Judiciary, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that 1, we are providing public access to the meeting by telephone, with additional access possible by video and other electronic means. We are utilizing Zoom software for this electronic meeting, and all members of the committee and selected legislative staff have the ability to communicate contemporaneously in this meeting through this platform. And the public has access to contemporaneously watch and or listen to this hearing via Zoom calls and YouTube and via telephone by following the directions and links that you can find at the New Hampshire General Court website. We have provided public notice of the necessary information for accessing the meeting at the Senate calendar, in the Senate calendar. We are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remote Senate, all one word, at leg.state.newhampshire.us. That's remote Senate, all one word, at leg.state.newhampshire.us. Or you can call 603-271-3043. That's 603-271-3043. In the event the public is unable to access the meeting, it will be adjourned and rescheduled. Please note that all votes taken during this meeting shall be done by roll call vote. Finally, we will start the meeting by taking a roll call of attendance. When each member states their presence, please also state where they are and if anyone else is in the room with you during this meeting, which is required under the right to know law. So we'll start the roll call. Senator Chandley.
This is Shannon Chandley. I am at home in Amherst and
Oops, you went back on mute.
Did you hear me? Did you hear? I'm alone in the room at this time. I'm in Amherst, New Hampshire. It's Shannon Chandley.
Very good. Senator LeVake.
Good afternoon. My name is Senator Melanie LeVake. I am at my home in Brookline. There are people in my home, but I am alone in the room.
Senator Carson.
Good afternoon. This is Sharon Carson. I am at my home in Londonderry and I am alone.
Thank you. And Senator French.
Morning, Harold French in my home in Webster, and at this time alone.
And I am Senator Hennessy, and despite my background, I am actually in Hanover, New Hampshire at my home, and I am alone in this room, although there are people in other parts of the house. Thank you. Before we begin the hearing, I ask that we have a moment of silence to honor George Floyd, whose memorial services were this week, and for all of those who are standing up to and experiencing systemic racism and race-based violence in our country and around the world. Thank you again. Thank you for participating in this full judiciary hearing this afternoon. We will have many speakers today, and we recognize that there will be passion on both sides of these important issues. First, I want to be sure that the procedures are clear in this new way of meeting. Today, our host, Ava, will be calling on individuals who have signed up. If you did not sign up, you can do so on the General Court webpage or by raising your hand virtually. If you are calling in, you can raise your hand by pressing *9. If you're having any problems, feel free to contact our staff via, again, remotesenate@ledge.state.newhampshire.us. We want to hear from everyone who wishes to speak. In order to fulfill this obligation, we will need to limit everyone's testimony to 3 minutes. The good news is this time I will not be the one interrupting you, but we will have someone who will interrupt you after 3 minutes. Please finish whatever sentence it is you're in the middle of, and that will be the end of your testimony. One exception to the 3-minute rule is the prime sponsor, who will be able to speak longer, but we are again asking prime sponsors to limit their testimony as much as possible to ensure that we can hear from everyone who has signed up to speak. If you have written testimony that you have not yet submitted, please do so as soon as possible. This is likely to be, I hope not, but it's likely to be a very long hearing. And we thank you in advance for following the rules as we've presented them. And I'm just going to make a few tips to remember while testifying. First of all, please try to summarize the key points of your testimony. Please do not repeat what has already been said. I know that's hard, but please do not. And instead, make your testimony unique by telling it from your perspective. Some of the most powerful, memorable testimony is brief and uniquely personal. So we will begin. And the chair is going to recognize Representative Rennie Cushing, who's the prime sponsor of House Bill 705. So I guess I need to say I'm opening the hearing on 705, is that correct? So I am opening the hearing on House Bill 705, and the chair is recognizing Representative Rennie Cushing.
Good afternoon, Representative Cushing. You should be all set.
Am I unmuted?
Yes.
Hello? Okay, thank you, Madam Chair, members of the committee. For the record, I'm Representative Rennie Cushing from Rockingham District 21. I'm the chair of the Criminal Justice and Public Safety Committee, and I'm also the prime sponsor of House Bill 705. And I'll be mindful of the admonition from the chair to try to be concise. House Bill 705, the Crime Victims' Rights Enhancement Act of 2020, is the result of a series of consultative meetings that took place over the past year and a half involving a number of stakeholders, including the Office of the Attorney General, Department of Corrections, the Coalition Against Domestic and Sexual Violence, the Office of Victim Witness Assistance, the Crime Victims Assistance Commission, the ACLU, UNH School of Law, and others. And what it consisted of is doing a deep dive into the crime victims' rights laws that exist in the statute. And the product consists of a number of changes, some significant, some I think frankly significant, others are just fine tuning it, that include increasing the maximum recovery for crime victims from the Victims' Compensation Fund from $35,000 to $40,000. We're in a situation now where there are crime victims who need assistance who have maxed out on that, and we don't want to see that happen. Establishing confidentiality procedures for information used to support restitution to the crime victims funds. It expands the offenses covered by the Crime Victims' Rights Bill of Rights. It expands the rights available to crime victims. it requires the Department of Justice to develop a crime victims' rights card, and it also requires establishing professional guidelines for victims assistance providers. One of the changes that it makes that is relevant to the amendment that is going to be proposed is that it eliminates the statute of limitations for adult victims of childhood sex abuse, or people who were sexually abused as a child. In addition, the bill established a study committee that was tasked, among other things, with trying to develop an effective mechanism for victims' rights. We did a whole lot of work in our subcommittee over the year and a half, and the two areas that we focused on that we recognized needed to be addressed is what is an effective enforcement mechanism for victims' rights, and institutionally, should there be some kind of oversight in the form of an ombudsperson. We had very intense and productive conversations. I think we agreed to put forward what the work that we've done, and we hope to be able to complete that work. I will note that this passed the Criminal Justice Committee 17-3, and passed the House on a voice vote. It passed 21-0 out of House Finance, and it's on your way to you. And I would urge that the Judiciary Committee recommend ought to pass on 705.
Thank you, Representative.
3 minutes.
You did very well. Are there questions? Seeing none. Thanks so much for being here, or sort of. They're virtually here.
Thank you for allowing me to be virtually present with the Senate Judiciary Committee.
Our pleasure. Thank you.
Okay, so next we have Rory McDonald. However, they are not on the attendees list. So if you are calling in, please feel free to dial *9. In the meantime, we'll just call our next speaker, which is Aphrodite Michael Katulas. I apologize if I pronounced your name wrong. You should be all set.
Hi there, how are you? Can you hear me okay? Hi. So I myself am a previous victim of violence. I was born in Dover, New Hampshire, and had gone away for quite a while, came back and was in some serious situation. This system that you guys, sorry, I'm a little nervous. The system that you guys have in this bill right now, I got on board. I'm really excited about it, because anything that has to do with victims having a little bit of extra, anything is so big right now. I'm actually just a little bit passionately shaking at hearing this kind sir speak, because when you don't have anyone, and you don't have, you can't even trust who you thought you trusted. This is such a huge thing to be able to have people that are in your corner and are willing to listen and be there. I don't have a whole lot to say, but I'm very passionate with the fact that you guys are here and pulling these resources together for people like myself who have felt lost and forlorn, and have, but by the grace of God, could barely stand back up on my own 2 feet. So I just want to say thank you. And I'm fully here, and I'm fully supporting all of these awesome moves that you guys are doing to really better the lives of men and women everywhere. It's a really hard road to climb up from places of victimhood, if you will. And I'm a firm believer in being a victor and not a victim. And I think that this really might have some cool details insofar as getting a lot of more people to that realization. So that's all I wanted to say. I just wanted to say thank you and know that I'm here and I'm supporting you guys and all that you do, and very grateful. Thanks.
Thank you.
Okay. The next speaker we have is Catherine Cooper. It appears Ms. Cooper is muted on their end. Right. Well, it appears there might be some technical difficulties. So The next and last person we have signed up to speak to the bill is Albert Schur. However, he is not on the attendees list. So if you are calling in, please feel free to dial *9 and that'll virtually raise your hand. Or if you are here virtually, please raise your hand. But other than that, that is the last speaker that we have. I see no hands raised at this time, Madam Chair.
Thank you. And therefore, we will close the hearing on House Bill 705. And then I would like to open the hearing on Amendment 1305. I'll read the title and then the bills that are contained. Amendment 1305 title is an act relative to sexual assault, sexual misconduct in higher institutions, in institutions of higher education, and the rights of victims of crime. The bill incorporated into 1305 are the following: 508, Senate Bill 508, an act extending the statute of limitations for civil actions based on a sexual assault. Senate Bill 679, an act requiring institutions of higher education to adopt policies on sexual misconduct. House Bill 160, an act removing the exception for married minors for the definition of sexual assault. House Bill 1495, an act prohibiting the sale of over-the-counter rape test kits. And House Bill 705, which we've just heard, an act relative to the rights of victims of crime, increasing the cap on assistance for victims of crime and establishing a committee to study the needs of crime victims and enforcement of statutes governing crime victims' rights. So we are ready to call members of the public.
Sure. So then first we have to speak is, again, Representative Rennie Cushing.
Thank you very much.
Good afternoon.
Good. Thank you very much again. I'm the same person that spoke before from Rockingham District 21, and I appear in support of the proposed amendment. Senate Bill 508, extending statute of limitations for civil actions based on sexual assault. I'm a co-sponsor of the bill. The question of statute of limitations came before Criminal Justice Committee. This was in a criminal sense. In criminal statutes, I do know that there's probably unanimity or close unanimity amongst the members of the Criminal Justice Committee on the issue of eliminating statute of limitations for childhood victims of sexual assaults to pursue civil recovery. And as I alluded to in my presentation on House Bill 705 component, that part of the bill limits the statute of limitations for eligibility for victims' comp funds, and it relates to this provision of Senate Bill 508, because the way our victims compensation fund works is that if there are other funds that are available to a victim, or if there's a recovery that's made, the monies go back into the victims comp fund. So this would actually serve the interest not only of the individual victim, but also of the crime victims compensation fund itself, where a childhood victim of sex abuse be eligible to make a recovery and to gain a recovery. Senate Bill 679, I defer entirely to the 24 sponsors of this bill, which I believe are every member of the Senate, and I certainly, having read the bill thoroughly, I endorse it. On Senate Bill 1601, to remove the exception for married minors from the definition of sexual assault, that passed the House 212 to 140. It just came before the Criminal Justice Committee. We recommended 20 to nothing that the bill ought to pass. As you may have heard, the House had a little glitch and we were not able to act upon that yesterday, but I would certainly applaud the Senate for including the language of this bill in an amendment to 705. House Bill 1495, that came through the House Commerce Committee, again, that it prohibits the kind of the scam of over-the-counter rape kits. And with that, I just thank you for assembling these important criminal justice reform measures to protect, victims of sexual assault and victims of crime in general.
Thank you so much again.
Okay. Next, we have Senator Waters, which Senator Waters signed up to speak. However, he is not on the attendees list. So if he's calling in, Senator, please feel free to dial *9. Senator Fuller Clark. Let's see here. Hi, Senator.
Can you hear me?
Yes.
Great, great. So Senator Martha Fuller Clark, representing District 21, which is the city of Portsmouth and 6 seacoast inland communities. And I testify today as the prime sponsor for Senate Bill 508. This legislation, as originally submitted, would remove the statute of limitations regarding civil action related to victims of sexual assault. Studies over the past several years attest to the fact that often victims of sexual assault repress the memory of such assault for many years. And then when that memory surfaces, it may occur many years after the current statute of limitations that is currently in law. Therefore, the victim would not be able to seek redress for such an assault. And the purpose of this legislation is to support those victims of sexual assault, regardless of the time frame in which such assault may have occurred, and allow them to seek appropriate justice with civil action. I also support Senator Hennessy's amendment to the original bill and trust that she will speak to that amendment, which occurred in the Judiciary Committee after the bill was submitted. This is extremely important legislation, and we need to recognize the injustice is done when victims of sexual assault are not able to seek appropriate civil redress. So thank you very much. I hope you will support the original bill with the amendment. That is the end of my testimony.
Thank you very much.
Okay, next we have Jennifer Pierce Weeks.
We actually had her further down the order. It's supposed to be Lynn next.
Understood.
Lynn Sholett.
Gotcha.
Sorry.
Let's see here. All right, we have Lynn Sholett. Should be all set.
Wonderful, thank you. Good afternoon, Madam Chair and members of the committee. My name is Lynn Sholett. I'm the Executive Director at the New Hampshire Coalition Against Domestic and Sexual Violence. And I just want to say thank you for creating this opportunity to be here. I know it's been a lot of extra work for all of the senators and the staff to make this opportunity possible. The coalition stands in full support of Amendment 1305 to House Bill 705. Touching briefly on each of the 5 areas, beginning with what was originally House Bill 705 that strengthens crime victims' rights. This is so important for several reasons. Victims suffer myriad costs as a result of crime: healthcare, counseling, property that's damaged or stolen. Crime victim compensation reimburses them for critical costs. And by raising this cap, we will ensure that those victims who have the most significant losses don't bear the brunt of them. The other point that I'd like to make about this particular section of the bill is that it clarifies the right of victims to be present and to be heard at specific hearings during the criminal justice process. Those are absolutely fundamental to victims' meaningful participation in a prosecution. The original House Bill 1495 that prohibits the sale of evidence collection kits that a rape victim could do at home is deeply problematic. The coalition is very concerned that selling a victim a kit that he or she could do at home would run the risk that a victim will not get the critical health care that is so important to their healing. I apologize. You will hear from other statewide leaders today about the importance of the provision of medical care to victims and the risks when they are not treated. Even more alarming, however, though, is that we believe these kits are selling victims a lie, a false promise that critical evidence will be admissible in a prosecution when it will not. The original Senate Bill 508, which removes the civil statute of limitations, is a significant advancement for victims of sexual assault in New Hampshire. Specifically, children who are sexually abused often wait to disclose. Many of them do not disclose at all. In fact, the average age of disclosure is 52. Lifting this artificial time limit provides victims with the time they need to heal before holding an offender accountable. House Bill 1601 removes the married minor exception from the sexual assault statute. Although we've done a great job modernizing our marriage laws in New Hampshire and raising the marriage age, it is still important to ensure that minors who are married and adults with disabilities have the same protections as others. Finally, the campus bill. Thank you, Senator Hennessy and all of the other sponsors who have joined in this comprehensive effort to improve campus environments and ensure that learning environments are safer for all. The provision of confidential services, more accurate data collection, and evidence-based training will improve the educational environment for all students in New Hampshire. Thank you.
You. Are there any questions?
What do we eat? Okay.
Yes,
Senator French has a
thank
question.
you, Madam Chair. And Lynn, you're still on?
I am, Senator. Can you hear me?
Yes, I can. Thank you. Could you tell me what a over-the-counter rape test kit consists of?
I would be happy to. I also know that we have several medical providers who are lined up after me to testify who might be better able to tell you what is in those kits. But I do know that they are a series of materials that would allow a victim to collect evidence from their body that could be submitted. There are a lot of challenges with that, though, in terms of giving victims adequate instruction, where that kit would be analyzed, whether or not it would be admitted into court. The existing evidence collection kit that is used in New Hampshire is consistent statewide. Every hospital uses the same kit. And if you're asking a literal logistical question, it's a cardboard box that includes things like paper sheets and swabs and a lot of documentation. And the nurses who are coming after me would definitely be able to answer that in more detail.
So I guess my question is, we usually don't outlaw the sale of these items. Swabs, paper, the box. Is it the instructions or the, I'm just trying to figure out what we're outlawing here and giving $1,000 penalty for.
Thank you for that question, Senator French. Absolutely. It is not that a swab or a piece of paper is a problem. The problem is that this would be sold to someone at one of the most traumatic points in their lives, within hours after being sexually assaulted. And the person purchasing it would have the understanding that they are collecting evidence from their own body that could be used to hold that rapist accountable. The problem isn't the actual swab or the piece of paper. It's the misleading promise that's coming along with it.
That it could be used in court.
And our concern is, and after consulting with a lot of prosecutors, is that it would not be able to be used.
Yeah, no, I agree with you. Thank you. Thank you.
Thank you very much.
Any other questions? Nope, seeing none.
So we actually have a hand raised, which is Daniel May. Daniel, you should be all set.
Can you hear me? Because I'm
Yep.
not Dan. I do know him. I'm actually Rory. I was in line to speak in the last one and my microphone wasn't working.
My apologies. Your name
No,
appears on Zoom.
it's user error 100%. I am really, really grateful that you guys are looking into this stuff. I am a multiple-time domestic abuse survivor, and without the help of a lot of the people that are supporting this right now, like Lynn, I wouldn't have had access to a lot of things that I didn't even know existed that would have drastically affected my court case. I 3 times was denied restraining orders when I desperately needed them for lack of evidence and lack of education on how the judicial system worked. And with the programs like the ones that she's working with that are advocating for this right now, I was finally able to get one and get help afterwards. I think if this stuff was allotted to people, especially after, you know, a statute of limitations goes up, because women socially, we're taught not to talk. Like it's sadly another social systemic problem with abuse victims is that we're going to be not heard or not listened to, and the mental health stuff is not there afterwards, and it's not really there before. I think something like this, being a rape victim myself, not realizing that it could have really drastically affected me in court, it's really important. Something like this, if you guys can't outlaw it, should at least have a really thorough explanation and a disclaimer that this stuff could really make their case inadmissible, and if they're worried about the emotional backlash from that they really should seek a professional first.
And I apologize for interrupting. Just for the record, and this for the sake of the aid to the committee, could you just state your name, please? Just because there is some confusion with.
No, Rory McDonald, not Daniel May, I promise.
Perfect. Rory McDonald, thank you.
Yeah, you're very welcome. Thank you for letting me speak, you guys. I appreciate you taking the time to do all this.
Thank you. Are there questions? Seeing none. Move on.
Next, we have Brian Harlow.
Hello, can you hear me?
Yes.
Okay. I'd like to thank the Senate Judiciary Committee for prioritizing issues related to victims of crime, and specifically policies aimed at improving the lives of victims of domestic and sexual violence. During the COVID-19 crisis, we have seen a surge in the number of cases of domestic violence and in the severity of these acts. Unfortunately, many families were not made safer by staying at home with abusers. When the legislation was first brought forward as separate bills, they were already critical to strengthening the safety of survivors, and now we need these provisions more than ever. Each one of these proposals before you, including the policies in the next amended bill before you, House Bill 1645, are critical to ensuring the rights and safety of victims of abuse. As a survivor of crime, I'm asking you vote to support this important bill, as well as the amendment to House Bill 1645. And when I say survivor of crime, I'm referring to the intimate partner violence I witnessed between an alcoholic father and a young mom with the bluest and saddest eyes I've still ever seen. I also personally know the despair of a preteen child with no voice and no lifeline experiencing abuse. During COVID-19, children, and mostly women in our state, are unseen and need us now. I'm grateful to each and every one of you for your incredible work on behalf of survivors. It matters so much. Thank you.
Thank you for being here, Brian. Other questions? None.
Righty. Next, we have John Gabrielli.
Hello. My name is John Gabrielli, and I'm the Executive Director of the Every Voice Coalition of Students Against Sexual Violence, and I'm from Manchester, New Hampshire. I'd like to begin by thanking the committee for taking the time to address this issue of sexual violence during a difficult and challenging time for us all. I come before you today in strong support of Amendment 1305, and in particular in support of a bill you have heard and reported out favorably before, Senate Bill 679, an act relative to policies on sexual assault in higher education institutions. Since this is a bill you have heard before, I won't summarize the legislation again, although I am, of course, happy to answer any questions if there are any. I will simply say this: the passage of Senate Bill 679 would represent a huge step forward for students and survivors across New Hampshire, and I would like to thank those responsible for their support. Specifically, I would like to thank this committee for hearing Senate Bill 679 and seeing fit to report it out favorably, as well as the entire Senate for passing this bill unanimously by roll call vote on March 12th. I would like to thank our 24 bipartisan co-sponsors in both the House and the Senate, including just on this committee alone, Chair Hennessy, but also Vice Chair Chanley, Senator LeVake, and Senator Carson. I would also like to thank Governor Sununu for his support and letter of endorsement. Second, I think it is important to acknowledge that this bill represents the product of many hands. I would like to thank those who testified in support of Senate Bill 679, as well as those who have aided materially in its formation, including Lynn Gillette, Amanda Grady-Sexton, and the New Hampshire Coalition Against Domestic and Sexual Violence, Kitty Kiefer and the New Hampshire Campus Consortium Against Sexual and Interpersonal Violence, SNHU, UNH, the University System of New Hampshire, and the Community College System of New Hampshire, And finally, and most importantly, I did just want to thank the students of New Hampshire who have had the courage to speak out against injustice. Though there are too many to name here today, I would like to thank in particular our Every Voice New Hampshire Committee co-chairs, Sophia Miller, Maggie Johnston, and David Millman, as well as our steering committee members, Cece Henderson, Uma Ramesh, Davis Bernstein, and Maggie Flaherty for their committed advocacy. From the beginning, Every Voice has been a grassroots movement for justice led by students and survivors, for students and survivors. Thank you for being willing to listen and for helping us turn this vision into a reality. I now am finished with my testimony, and if anyone has questions about the substance of the legislation, we'd be happy to answer them.
Thank you for your testimony, John. I see no questions. Thank you for being here.
All right, so next we have Catherine Cooper. Let's hope they can connect now.
Can you hear me now?
Yes.
Oh, thank you. I apologize for that earlier. For some reason, I couldn't get my computer to unmute. I do hope that you have my written testimony and that you can refer to our comments on the last bill. Regarding this bill, we have some concerns about the amendments to House Bill 705, beginning with the statute of limitations portion. We object to this change just based on fundamental fairness. Although we are criminal defense attorneys, we do deal with people who are coping with similar accusations in the civil context as they are in the criminal context. And one of the examples that was given earlier was based on the need to have this because of recovered memories. Unfortunately, many recovered memories are unreliable. And if a person is faced with an accusation for which they are actually innocent, it's extremely difficult to garner evidence and come up with information to defend yourself when decades have passed and you are essentially attempting to prove a negative. So for that reason, we oppose that segment. We also have some concerns with the sexual misconduct at institutions of higher learning. That hasn't been addressed significantly here, but my understanding from speaking with one of my members who does quite a bit of work in this area is there was just a new segment of regulations that were passed by the federal government last month, and that there's a significant amount of conflict between the language proposed here and the new regulations. So we do have some specifics in the written testimony about particular portions of this that are troubling from a defense perspective, but we'd also just encourage that this be put off until there's additional time to absorb those new regulations and figure out how to make New Hampshire legislation mesh with what the federal government is doing. I would also point out quickly that we support banning the over-counter rape kits for the same reasons that were given by Lynn, and also in addition to the fact that we are concerned that such kits could result in wrongful convictions. Unless there's any questions, I don't have anything further that I think I need to highlight other than what's in our written testimony. Thank you.
Senator French.
Yes, thank you, Madam Chair. Ms. Cooper?
Yes.
Just on the statute of limitations, I've had a problem with that. Does that mean that people, an 18-year-old and a 16-year-old friends dated, and then when that 18-year-old becomes 82 years old and the woman was 80 years old, could a lawsuit be brought at that point?
Yes, this completely would abolish a statute of limitations, which in general statutes of limitations are set in place in order to make sure that there's a specific time frame in which a charge or an accusation civilly can be brought. So this gets rid of any kind of time frame. I mean, currently we have a very long time frame, which is often already problematic in terms of defending charges that are very old. But this would get rid of a time frame altogether.
That's how I read it. Thank you.
Any other questions? Seeing none.
Next, we have David Goldstein.
Can you hear me?
Yes.
Oh, great. Thank you. Good afternoon, everybody. Thank you for conducting this hearing today. And by way of introduction, my name is David Goldstein. I'm the Chief of Police in the City of Franklin, and I represent the New Hampshire Association of Chiefs of Police. And I will certainly stay within my 3 minutes. I'd like to read a very short statement from the chiefs. And we are deeply committed to ensuring the safety of victims of domestic and sexual violence. We join advocates and medical professionals in their support of HB 705, a bill to clarify and enhance the rights of victims. In particular, we are pleased to see that there is an effort to prohibit the sale of do-it-yourself rape kits. We believe these kits provide a false sense of security to those who have experienced sexual assault. It is important that the chain of custody be protected in evidence collection for both defendants and victims. These kits are not viable alternatives for forensics or forensic evidence that's been collected. And it's very hard to imagine a scenario where evidence collected from a do-it-yourself kit would hold up in a court of law. Finally, we encourage all victims to seek medical assistance after any sexual assault, whether or not they decide to move forward with a report to law enforcement. Thank you, and I'll any questions, I'd be happy to answer.
Thank you very much. Are there any questions? Seeing none, we can move on.
Next, we have Aphrodite Michael Katulis. Again, I apologize if I mispronounced your name.
Oh, hi, Aphrodite Michael Katulis here. I've just been listening in now. I myself, I have a little bit of a complex victimhood, if you will. I was a childhood victim of incest, and my abuser has long since passed. And after going through a series of deep therapy, it's kind of funny that I'm in this meeting right now, because I went up to kind of have a meeting the other day about some therapy, about some of these issues. And I personally had a breakthrough, like I'm talking 3-4 days ago. And the fact of the matter is, like, my abuser's in the ground, and I'm just kind of sitting here, and I'm just like speaking for maybe people that have gone through some really serious stuff, because if you've been abused during infanthood or childhood, sometimes the little psyche can't quite grasp what is going on. And after many years, and maybe even speaking with other members of family or other victims of said individual, it's kind of like it kind of shakes you up a little bit to know that, like, if you don't even have a voice, where can you go? And maybe, we can all get together to maybe find out, like, if there is something about the statute of limitations where it is unfair, maybe that you can't have it stretch so super far. We maybe can get some real mental health stuff going on for people such as myself who have been through such horrendous things, because you end up being a repeat victim throughout your life, possibly with others. And it is like a really hard thing not to get closure. It's a really hard thing by the time when you get closure, if they are in the ground. So, like, mental health is everything here. And I'm not trying to beat a horse to death or anything. I just want to give some views here about someone who is sitting here as a rape victim, as an incest victim, and, like, just kind of feel it in your heart to imagine what it's like to go through your life, just to wake up one day and get hit with a memory like a Mack truck and not know where to put it, and I know a lot of the times legalistics don't heal things, but if the legalistics can't, we'll kind of brainstorm to get something together for the people that, can get a little help beyond the courtroom. And that's all I want to say. Just please keep in mind that there are people here with very sensitive issues, and I'm not saying, like, and I know that if you don't know, you don't know, but let us be your voice and let us kind of tell you what you don't know. And we're humble and we're kind, and victims generally aren't even ones to open their mouths. So even being here is hard for me, and it's hard for me to share all of this with all of these beautiful stranger faces. But it's kind of divine intervention that, you know, we have people like Miss Rory and myself here that can be your voice. Like you get, you know, everyone's sitting around like, what should we do? What should we do? Let us help. You know, and I'm fully available anytime for anything that anyone may need to ask questions for, and so far as victimhood and, you know, maybe how to work around some of these really sticky situations. And I'm sorry, I'm not the most professional individual and I don't have all the legal jargon here, but I have a heart and I have experience and I want to help. So that's all I'm saying. Thank you.
Thank you. Are there any questions? Seeing none, we can move on.
Next, we have Marissa Chase.
Good afternoon. I'm going to yield my time to Attorney Tony Scullambrini, if that's okay.
Certainly.
Okay. Anthony, you should be all set.
Thank you. Good afternoon, members of the committee. Thank you for giving me the opportunity to talk. My name is Anthony Scullambrini. I am an attorney practicing in Nashua, and I am testifying in support of repealing the statute of limitations and in opposition to the at-home rape kits. I just want to go through and make a couple of points. First of all, the statute of limitations in civil cases is shorter than the statute of limitations in criminal cases, which frankly doesn't make any sense. Second, the science that has come about in recent years regarding the disclosure that victims go through, the process of disclosure, shows us that it is a long process, and therefore by eliminating the statute of limitations in civil cases, you will allow victims to come forward on their own timetable as opposed to some artificial legal timetable. I also think that it won't open the floodgates if you repeal the statute of limitations in civil cases. First of all, proving sexual assault is exceptionally difficult, and so there aren't a lot of these cases to begin with, especially when compared to other kinds of civil suits. Second, most of the time, the criminal cases go forward, the perpetrator is convicted, and if they're convicted, then they become essentially judgment-proof. So this is not going to open the floodgates. We're not going to see a ton of litigation. I want to address quickly Senator French's question to Attorney Cooper. While it is technically possible to have an 82-year-old get sued by an 80-year-old, the reality is that most of the time that doesn't happen. Oftentimes in cases, they aren't people that are harboring these long-standing resentments. And usually in the cases that I've dealt with, in the case of people that I've talked to, you know, the oldest people are in their 40s or 50s. And so while it is possible if you repeal the statute of limitations that could happen, it just doesn't seem like it's something that's all that likely to happen. In terms of the at-home rape kits, I want to reiterate what the chief from Franklin said. Mr. Goldstein indicated that these kits are very unlikely to be admissible. As somebody that's practiced and done criminal defense work and civil work, I can't see a way in which these tests would ever be admitted into trial. There's a reason we don't have at-home trials or at-home field sobriety tests, and the same reason we wouldn't have at-home rape kits. They have problems with chain of custody, as other people indicated. Furthermore, given the nature of sexual assault nurse examiners' jobs, I think that it's clear that they require specialized training and expert knowledge, and having someone administer this to themselves at home wouldn't be able to meet those standards. Additionally, I think that asking victims to do this when they are at their most fatigued and most tired only introduces unnecessary error. There's a reason why these kits have been opposed by law enforcement and AG everywhere, and it's because they just do not work. The other thing that I would point out is that
I apologize to interrupt. However,
Sure.
your 3 minutes is
Sounds
up.
good.
I apologize.
All right, I'm good.
Senator French, looks like you have a question.
I do. Tony,
Hi, Senator French.
how you doing?
Good. How are you, sir?
Good. Hey, I agree with these kids not being allowed in court. I can't see how they could be. However, the prohibiting the sale of them, I do question, what if they're called proof of intercourse kit? And you know, by changing the name, how can we prohibit the sale of things that are lawful to be held? And the other question I'd like you to answer, what about internet sales of these where they're being sold in another state and ordered online? Could you answer those, please?
Sure. So I'm going to take the second question first. In the case of the Me Too kits, Lita Health's kits, they changed their name after some run-ins with attorneys general. The Attorney General of Michigan actually sent a cease and desist letter to Amazon, and Amazon took them down. I don't think that the New Hampshire legislature has the power or jurisdiction to regulate kits sold in other states. But I do think that there are practical steps that could be taken to prevent that from happening. And then to answer your first question about what they're called, I think that the problem here isn't just that we're offering false hope. It's that what we're doing by having these kits available could actually make the situation worse. I mean, imagine if they were offering, you know, a miracle pill that would instantly make you not drunk, but it wasn't tested well enough to know if it worked. And all of these people who are drunk drivers are getting out of a bar and they decide they want to take a chance on one of these pills. I mean, there's just too much at stake, and there are too many people that could be harmed by these kits to allow them to go out into the public without some sort of, you know, better insights into how they work, what the purpose of the kits are, better training. I just don't think that we can get there, especially because you can always go to a hospital, even when COVID-19 is going on, and see a sane examiner for free and anonymously.
Follow up?
Yes.
But my question is, how do we enforce legislation of this type? Should we pass it?
I mean, I think you enforce it the same way that you would enforce any other sort of ban on an item. You know, there are certain things that are prohibited. And when, for example, before Jen Coffey's bill to repeal switchblades were banned in New Hampshire, even though in theory they could be used in other states and were legal in other states. It's not a matter of enforcing it the same way that drugs are. There's all sorts of items that are sold through interstate commerce that are prohibited in New Hampshire, but could be allowed in other states.
But what are we banning by passing this?
I see what you're saying.
The name, what it's called, or the items within the kit?
My understanding of the legislature, Senator, is that it's banning the kit. You know, if they changed the name and they called it like, you know, fun birthday party surprise, and it was exactly what it is, I think that the way that the legislation is written is designed to ban the kits themselves and not what they're called. So in the same way that you couldn't call, you know, switchblade like shaving device, it doesn't really matter what it's called, it's what it's doing or what it contains that the legislation is aimed at.
Okay. Thank you.
I don't see any other questions. Thank you.
Next, we have Christiana Golden. Ms. Golden, you should be able to unmute yourself on your end. Okay, we might just have to revisit. Christiana, I don't see, if you are calling in and you want to raise your virtual hand, please feel free to do so at this time. In the meantime, I will go next on the list, which is going to be Michelle McMurray.
Hello, hi, can you hear me?
Yes.
Perfect, excellent. Thank you for having me this afternoon. I am a sexual assault nurse examiner. I've been so for more than 20 years. I'm also a nurse practitioner. And with regards to these home sexual assault kits, I have to say that, what I do as a sexual assault nurse examiner provides victims a comprehensive medical exam. I'm able to help integrate advocacy. I can prescribe any medications, including, STI prophylaxis or any other medications that are needed. If I need to get an x-ray or what have you, I can do all of that stuff. With a home sexual assault kit, there's no chain of custody. There is not an opportunity to have advocacy, present. There's not an opportunity to have a comprehensive medical exam and follow-up care. And, I have to say that, both there's long and short-term consequences of sexual assault, and with a home kit, nobody will have access to any extra support, which, as we know, victims of sexual assault, need. So I have to say that, I have to disagree with allowing these kits to be marketed and sold.
Thank you.
I think I'm under 3 minutes.
You are. Does anyone have a question? Seeing none.
Thank you. All right, so we'll give Christiana one more try and see if she's able to unmute herself. And if not, we'll move down the list here. Okay. Well, if at any point you are able to reconnect, again, please feel free to raise your hand virtually or dial *9. In the meantime, we have former Senator Peter Bragdon.
Okay, can you hear me?
Yep.
Oh, perfect. So thank you. Good afternoon, Madam Chair, members of the committee. Thank you for the opportunity to testify this afternoon. My name is Peter Bragdon. I'm here representing Lita Health, a company in the process of developing an at-home sexual assault evidence collection kit. Lita is opposed to Section 17 of the amendment before you, the section that would ban the sale of these kits in New Hampshire. Though others will be testifying about the effect of Section 17, my purpose is to provide some context. Section 17 started off as HB 1495, which had a hearing in February before the House Commerce Committee, a seemingly odd committee to deal with sexual assault issues. The committee recommended passage on a split vote, 12-7, and then it passed the full House. Unfortunately, neither Lita nor other similar companies were aware there was a bill in the New Hampshire legislature that would ban their products until several weeks after the House vote. As a result, the House committee and the full House only heard one side of the story, the side that says these kits are bad, or as someone just said, these provide false hope, and that they have no value to law enforcement or sexual assault survivors. Some even went so far as to call them opportunistic scams. Today, you will hear from members of the law enforcement community, including a former FBI agent who was a subject matter expert on forensic evidence, and also from a distinguished former child abuse and sex crimes prosecutor from neighboring Massachusetts, now with the Women's and Children's Advocacy Project at New England Law. They will tell you at-home kits do have evidentiary value and can be a useful tool in empowering survivors and bringing access to justice. You will even hear about how these kits have been successfully used in other jurisdictions in partnership with law enforcement and health professionals. Though not able to testify today, you have received written testimony from a certified sexual assault nurse examiner who has examined literally thousands of patients for sexual assault, who assures you that at-home products have important value to sexual assault victims who do not wish to report immediately. I encourage you to read that testimony as it talks about the various self-collected items already gathered as evidence by law enforcement and forensic nurses. You will hear from a member of the legal community who will address the misinformed claim that at-home kits will not be admissible in court. And you will hear from sexual assault survivors, some in person and some who sent written testimony, who will give some context as to why a vast majority of sexual assaults go unreported, especially on college campuses where up to 90% go unreported, and how having access to an at-home kit can remove a key barrier to reporting. And finally, we ask today that your committee, the only committee to hear both sides of the story, ask yourselves this question. Should we be banning a product that experts say has the potential to empower sexual assault survivors and has been successfully used in other jurisdictions? Or should we first look into this a little more and find a way to have law enforcement, health partners, and colleges work together to help bring justice to and empower sexual assault survivors? It seems to me that a study committee on this matter would be the appropriate step. Thank you very much for your time. I'd be happy to answer any questions, though I believe those testifying after me are probably better equipped to answer some detailed questions.
Seeing no questions.
Okay. Next, we have Jane Mason.
Okay, can you hear me?
Yes.
Great, thank you. Madam Chair and members of the committee, I oppose, oh, can you hear me still?
Yes.
Sorry about that. I oppose the section of the amendment that bans the sale and use of at-home evidence collection kits for sexual assault survivors. My name is Jane Mason, and I am the founder of the Preserve Kit, the only company that sold and donated at-home evidence collection kits. I am a retired FBI special agent with 28 years of experience in complex investigations and am a subject matter expert on the collection of forensic evidence. The bottom line is that almost 80% of all sexual assault survivors do not come forward to report the crime. This is the reason I developed the Preserve Kit. Cases like Christine Blasey Ford's may have ended differently if she had saved some evidence to support her claims. There is a great deal of information that supports self-collection of evidence. Besides the case related to Monica Lewinsky's blue dress, there is a tremendous amount of case law. There was a 1992 federal law under which many colleges encourage students to preserve evidence, whether they plan to report the crime right away or not. And there is a federal grant which supports the research for a website named surviverape.org, which states it may be possible to use evidence stored by the survivor/victim in a criminal investigation. Law enforcement routinely obtains evidence from crime victims. The fact that an item of evidence came from a crime victim does not inherently indicate there are chain of custody or admissibility issues. The last point I would like to touch on is a case that occurred earlier this year in Monterey County, California. At the outset of COVID-19, the district attorney's office worked with their counterparts to implement a protocol using the Preserve Kit for the collection of sexual assault evidence. I donated 75 Preserve Kits plus additional supplies for this innovative plan, which allowed sexual assault victims to collect their own evidence in their home with video guidance from forensic nurses. The Monterey County Assistant District Attorney has publicly voiced that she has no concerns about the admissibility of this evidence. She noted that any questions about admissibility would be addressed by the judge in future proceedings. The kits are incredibly vital for certain survivors, whether they can't get to a medical facility because of a pandemic or for any other reason. I ask that you empower all survivors with additional tools rather than banning tools and making it a crime to preserve your own evidence. Thank you very much.
If you're willing, Ms. Mason, I have a question.
Yes, absolutely.
First of all, are you aware that in New Hampshire, at least coming forward and having an evaluation at a clinic is free? So why would someone want to pay the extra money if they can get it for free at a clinic where they can have it saved and absolutely be evidence?
So I will probably go back to this a couple of times. I think the premise for my opinion is 8 out of 10 sexual assault victims don't do that. So we have 8 out of 10 who have nobody collecting their evidence, aren't getting any resources. This is statistics based on RAIN and Department of Justice statistics. And so I believe, though, that 80% of crime victims deserves some help. I, with my expertise, am able to help them with evidence collection. I agree, they need other resources, but I think that 80% of crime victims should just not be completely left out.
I'm wondering if you have any evidence that the reason 80% are not getting tests done or reporting is based on not wanting to go to a clinic as opposed to picking it up at a CVS or whatever else. I mean, most of the people I know, and including myself, who've been victims of sexual and violent assault, are people who don't come forward for a wide variety of reasons, not simply because they don't have access to a kit.
I'm sorry, could you repeat the question?
Do you have evidence that the people who are not reporting their rapes are not reporting it because they didn't want to go to a clinic?
I have done a lot of research on the reasons why sexual assault survivors don't come forward, and the reasons are myriad. There are many, many reasons.
Thank you. Senator French and then Senator LeVake.
Thank you, Madam Chair. Thank you, Ms. Mason, for coming to testify today. Might it be better for us to legislate a disclosure must be included in these kits versus outright prohibiting them? And the disclosure could be that this may or may not be allowable in a court of law.
If your committee would like, I would be happy to submit to you the instructions that are included. I have dealt with evidence for almost 40 years now, and I know the reality. There's no guarantee. So I have so many disclaimers within the preserve kit that there's no guarantee of admissibility, you know, that there are just no guarantees whatsoever. This is just an option for you in case you want to come forward later after that window of opportunity for evidence collection is passed.
Follow up? Thank you. So I take it you do have disclosures within your kits that you offer?
Numerous.
Okay, thank you.
Senator LeVake.
Thank you, Madam Chair, and thank you, Ms. Mason, for your testimony. Have you worked with the New Hampshire Attorney General, law enforcement, or even our hospitals to kind of ensure that there is validity in the testing of the use of these kits? Because what I'm hearing is that the testing is not valid or not sanctioned. Is it possible to work with New Hampshire to have it as a sanctioned kit?
I have always welcomed the opportunity to work with other entities, other groups. I would absolutely love to work with anyone in New Hampshire. Ironically, no one has ever reached out to me at all about my kits. And so when you say the validity of the test, it's literally, you know, how to package your semen-stained underwear in a bag, how to use paper rather than plastic to try to preserve more DNA so there's not as much degradation over time. Things like that. There are swabs in the preserve kit as well. So there's no basis to the premise that there's no validity to the test. You could use a Q-tip and swab semen off of your skin, and there's DNA in the semen, and if the profile comes forward, you know, it's evidence. There, you know, I think there's just been a lot of confusion about what the kit actually is meant to do and what it is.
Thank you.
I'm going to ask one quick more question. How much does the kit cost?
Well, okay. So originally I was going to have it distributed through my marketing plan. I didn't get to the marketing plan, so I didn't get this far, but my original marketing plan was to have it, have it put to colleges and their wellness centers and maybe places like Planned Parenthood, things like that, so people could get access to the kits. But during our product development, So many people came to us and said, well, if I'm not in college or I don't know how to get to Planned Parenthood or wherever we happen to be able to get the kits, how would I get a kit? So that's why we made the decision to start selling them on Amazon. We sold them for $29.95. And just to correct something that happened earlier, I removed the kit from Amazon. Michigan did not submit anything to Amazon to cease and desist. I took my own product off of Amazon.
Thank you. Are there further questions? Seeing none.
Okay, Senator. So before we move on in the list, Rory McDonald or Daniel May, as it appears, has their hand raised. So
Hi, my name is Daniel May. I'm a citizen of New Hampshire, and
I'm so sorry.
I have
I'm so sorry to interrupt. Oh, okay. You go ahead. I'm so sorry. There's just two hands raised and it had the same name. I apologize for interrupting.
Yeah. I'm Daniel May, and I'm a citizen of New Hampshire, and I apologize for that. My friend had tried to get into the meeting, so I sent her a link, and apparently it was the wrong link. So yeah, so she is me, but so I have just seen a lot of mishandling of a lot of rape cases in the areas. I don't know if there's a where I am from, but I've been hearing a lot in different areas of the country, and I don't know if these are rumors, but there's a lot of rape cases discovered in different police departments and things like that, that were backlogged or that they just weren't fully looked into and pursued to the fullest extent of the law. And so many people don't have faith in the system, and that's why a lot of people are using these over-the-counter rape kits and getting this first step to feeling confident enough to going to the police. I believe that they should go to the police and get a real rape kit done, but it's difficult because people just don't have the trust in their local police departments to get these things done. I've seen a lot of cases mismanaged due to rape cases, and that they really should have been fully looked into. So it's just a sad case, and that's just my personal experience from seeing from an outsider's view, because I've myself not been a victim of sexual violence in that so much as being a female. But when I was younger, when I was in Boy Scouts of America, I was sexually assaulted, and that left a lasting effect on me. And I just didn't have the faith to come forward to a police department to speak to them, because I just didn't have trust from what I had seen from other people that had done the same. So I'm just thinking that it would be great to possibly get that fixed so that people may have more trust in that, and that they can get in these rape kits. I mean, sure, they may not be admissible in court, but I do believe that they are a first step for many who believe that they have been raped, so that they have the energy to go and do it for the rest of it. And certainly after that, I believe that the senator that said that they should have a disclosure, they should absolutely be having a disclosure so that people know that that's not fully admissible in New Hampshire courts. And that's what I have to say about that. Thank you so much for hearing what I have to say on that issue, because it is something that I'm very driven about as well. And I appreciate all that you have done in your communities and making sure that the trust between everybody is helped out, and the people can raise their children in a safe environment. Thank you so much.
Thank you.
Senator, do you see any questions from committee members?
I do not.
Super. So we're going to move along. Wendy Murphy is the next signed up to speak. Please go ahead.
Great, thank you. Can you hear me?
Yes.
Great. Chairperson Hennessy and members of the committee, thank you for this opportunity to testify against the amendment, the proposed bill to ban at-home rape kits. My name is Wendy Murphy. I direct the Women's and Children's Advocacy Project at New England Law Boston, where I have also been teaching an upper class seminar on sexual violence law for almost 20 years. I'm a public interest litigator, former sex crimes prosecutor, former visiting scholar at Harvard Law School, where my work focused on injustices suffered by women in their capacities as victims in the criminal justice system. I sat on the first ever SANE board in Massachusetts, where decades ago, I raised concerns about the harm that was being caused by hospital rape kits, not only to women, but also to the integrity of criminal prosecutions. Statistics showed at that time and are pretty consistent today that kits were helpful only about 10% of the time and were in fact often harmful in the remaining cases. I also want to point out that I have an objection to the campus sexual assault bill, but I'm going to submit my testimony in writing. I just want to say as an aside that I think the bill as proposed, because there are so many lawsuits pending against Betsy DeVos right now because of what she did with the new regulations, that bill will lead to lawsuits against New Hampshire. Among other reasons, the bill subjects sex-based harm on campus to separate and different and worse treatment than race-based harm. And that would be unconstitutional under the New Hampshire State Constitution, Article 2 in particular, which guarantees women equal protection and equal treatment. And the bill as written subjects women on campus to separate, different, and worse treatment. And I think it's unconstitutional under your state constitution. But again, I'm going to submit my testimony on that in writing. My primary concerns about the hospital rape kits are that they overtest and they require needless disclosure of private information. Overtesting happens when kits are tested even when there is no need, which is routine. There's no court hearing to determine probable cause and so forth. This leads to the disclosure of irrelevant and deeply personal information, such as DNA from recent consensual sex partners. In 85% of rape cases, the defense is consent, which means there should be no testing done because the presence of DNA bears no weight on the only issue in dispute. Other needless disclosures occur because victims are forced to answer probing, irrelevant questions during the hospital intake process. They're asked about mental health, insurance, personal physician, prior drug and alcohol use, and prior sexual activity. None of these things should be disclosed in the absence of a case-specific reason to ask, but they are mandatory for all victims who submit to hospital rape exams. These needless violations of privacy are cited by victims as reasons they decline to report rape or decline to stay involved in the process after charges are filed. A recent case from New Hampshire illustrates my point. In State versus Shepherd.
I'm sorry to interrupt. Senator Hennessy, that's been 3 minutes.
Thank you very much. Thank you for your testimony. Are there questions? Seeing none.
Okay, next we have Haroon Chima. It appears they might be muted on their end.
Hello, ladies and gentlemen, can you hear me?
Yes.
Yes.
Thank you very much. Members of the New Hampshire Senate, my name is Haroon Chima. I am an experienced attorney speaking only in opposition to Section 17 of Amendment 1305. Section 17 on over-the-counter rape kits contains several serious legal deficiencies. The legislative history, including statements by some of those in favor, indicate that Section 17, while superficially about consumer protection, was drafted under the impression that such a kit would not be admissible in court. The intent to prohibit over-the-counter rape kits on admissibility grounds represents legislative overreach. Admissibility is a question of fact determined by a judge in a court case and is not a question of law determined by a legislature in a statute. This legislative overreach likely violates 2 articles of New Hampshire's Constitution. Article 37 requires the separation of powers among the legislative, judicial, and executive branches of New Hampshire's government. Article 73A empowers the Chief Justice of New Hampshire Supreme Court, quote, with the concurrence of a majority of Supreme Court justices, unquote, to, quote, make rules governing the administration of all courts in the state and the practice and procedure to be followed in all such courts, unquote. The state legislature does not and cannot have the authority in judicial matters, whether a particular type of evidence is admissible or inadmissible. Lastly, Section 17 effectively denies a survivor of sexual assault even the opportunity to attempt to admit the contents and test results of an over-the-counter rape kit into evidence. This denial is very likely a violation of the survivor's right to due process under the 14th Amendment of the US Constitution. I urge you to reject Section 17 of Amendment 1305 outright because it conflicts with both the New Hampshire and United States Constitutions, or instead to defer considering Section 17 and study the underlying issues. Thank you very much.
Thank you. Any questions? Seeing none, can move on. Thank you.
Okay, next we have Alexandria Bowen.
Hi, can everyone hear me?
Yes.
Awesome. Good afternoon. My name is Alexandria Bowen, and I'm a survivor of sexual assault. When I was 16, I was sexually assaulted by my then boyfriend, and I did not want to report for the sole purpose that no one would believe me, because where I grew up, it was very uncommon for someone who you knew to sexually assault you, and I was just extremely embarrassed. The thought alone of another person having to essentially violate me all over again just to get a judge and a jury to believe me made me physically sick. Along with that, I could not even touch myself in the shower. I couldn't bathe myself. And I could not imagine another person touching me. If I had an at-home kit available to me, I would have used it because I would have been myself collecting my own evidence rather than a complete stranger. I did not receive medical care. I did not receive mental health care simply for the fact that I did not report my assault. Due to my lack of trust in law enforcement and my general feeling of disgust, I've never truly come to terms with my sexual assault. I have dreams and I have awful memories. And recently, 3 weeks ago, I was diagnosed with PTSD because of my experience. As part of my personal healing journey, I've gotten politically involved and I'm currently president of College Democrats at my university and involved with various other organizations. Getting as involved as I have been has continued to stoke this fire inside me that motivates me to continue the battle. And I currently work for Lita Health because I am on a mission to empower survivors and ensure that they know that they are not alone. And I'm seeking to empower others through these kits. Please do not shut down the opportunity for survivors to take back their power just because a few lost theirs already. That is all. Thank you.
Thank you. I don't see any questions.
Likewise. Okay. Next we have Jalen Ortiz.
Hi there, can you hear me?
Yes.
My name is Jaylene Grace Ortiz, and I'm a survivor of sexual assault. I'm here today to oppose Section 17 of Amendment 1305. I'm aware that there are opponents of the at-home sexual assault kits, but I myself am a person who could have benefited from having one. I was sexually assaulted in my freshman year of college by a member of a powerful fraternity on campus. I felt so ashamed that I almost did not buy an emergency contraceptive pill the next day. I feared having to look the pharmacist in the eye and ask. Given that shame, I felt too uncomfortable going to a hospital and having a sexual assault forensic exam. I had heard in campus talk that the exams were often re-traumatizing. Now that I know that there are only 60 certified sexual assault nurse examiners in my state, I understand why that experience is often so triggering. New Hampshire only has 9 of these certified examiners. In addition to the shame I internalized from the assault, I did not have health insurance at the time. The combination of not knowing whether my costs would be covered, the fear of being re-traumatized, and the guilt I felt about my abuse led me to decide against receiving an exam. As a result, I felt powerless without evidence, and I never reported. Sometimes I still have to be in the same room as my abuser. Recently, several members of 2 fraternities at my university, NYU, have been accused of sexually assaulting 7 women. The members of the fraternities have been able to abuse their positions of power to silence these women for years. Not a single survivor received an exam for reasons similar to my own. I cannot help but wonder how this narrative might have played out differently if the women had easier access to these exams. Only 1 of the 7 survivors actually reported, and even then, she was still not tested. Given the immense trauma caused by sexual assault, Lita Health has created a support group with sex-positive facilitators and Title IX lawyers that I will be working with to support the survivors at my university. As you may know, nearly 1 in 4 college undergraduate women are sexually assaulted. In the United States, 1 in 5 women have been raped. I can vouch for the fact that typically the first instinct a survivor has is to shower. Having access to these kits could facilitate the exam process more rapidly and allow survivors to gather as much DNA as possible before taking part in activities that diminish the chances of detecting the evidence. I'm asking you not to prohibit access to these kits, which could eliminate the possibility of enhanced health and well-being of sexual assault survivors in the state of New Hampshire. I worry that it could also set the precedent for curtailing examination access to survivors in the rest of the United States. I believe that that would be a tragedy for all those like me who are survivors. Thank you for your time. I'm happy to take any questions.
Thank you for being here. Are there questions? Seeing none, can move on.
Next, we have Madison Campbell.
Hello, can you hear me? Yeah.
Yes.
Members of the New Hampshire Senate. My name is Madison Campbell. I'm a sexual assault survivor and I'm the CEO of Lita Health, a company designed to create resources for survivors of sexual assault. I'm here to speak in opposition of HB 1495, the amendment and bill created to kill at-home sexual assault kits. Lita was founded to serve the 3/4 of sexual assault survivors who do not report. That means they do not get access to the free services that those in support of HB 1495 speak of. It means they get no counseling, they get no STD testing, they dress their own wounds, they seek their own medical care. Perhaps most importantly, they collect their own evidence. Sometimes it's a scrap of clothing or a soiled undergarment. Sometimes it's a cryptic note in a diary. Sometimes it's just an image from the night preserved in their mind. Always something that will be with them for the rest of their lives. Those in favor of the amendment prefer the status quo, but the status quo has openly failed and continues to fail the 200,000 survivors who are still waiting for their kit to be processed, and quietly fails the million of other survivors unwilling or unable to access the current system. And today, that union asks you to vote against the interests of survivor, vote against choice, and vote to legislate away their access to the justice system. Our opposition says the kits will not be admissible, but they fail to mention these kits have already been used successfully. As has happened in Monterey County, California, these kits have been used and implicitly sanctioned by justice and health officials. Our opposition claims that these kits are dangerous because they sell false hope and do entirely on the premise they won't be admissible in court, conveniently ignoring the fact that there is now legal precedent in California for their use by law enforcement. They're so scared of a private sector solution that they want to put a cardboard box in the same category as weapons. We're not selling directly in the hours after an assault. Lita is a B2B company, which means that we do not sell to survivors. We sell to those institutions that are set up to protect survivors, just like the for-profit forensic companies, Searchy and Tritech, that sell the cardboard boxes mentioned prior by the speaker. We plan to connect victims directly to telehealth professionals that can provide both access to STDs and plug them into a community of resources designed to make sure they never feel alone. When DNA was first introduced into the judicial system, it was also fraught with controversy. As with anything new, things can get scary when we do not understand them. However, we believe the system that currently exists is not adequate. We've surveyed more than 900 survivors about their experiences, including many of your constituents, and 73% of survivors are in favor of at-home kits. You've already heard from 5 of them today. Senators, what side of history do you want to be on? The side that stands with survivors, the side that says we're not doing enough, in fact, we can do more, or the side that has decided that the way the world has worked for the past decade is okay for survivors, perpetuating a system filled with systemic problems? Thank you for your time, and I'm happy to answer any questions.
I do not see any. Thank you.
Okay, next, we have former Senator Peggy Gilmore. Senator, it looks like you might need to unmute on your end. All right, are you there, Senator? Oh,
I am.
Yep.
Am I good? Sorry about that. Thank you, Madam Chair, members of the committee. For the record, my name is Peggy Gilmore. I represent Freddie Strategies and Lita Health. I too speak in opposition to prohibiting self-administered sexual assault kits in New Hampshire. You know, I'm a nurse by profession, and I've spent my life caring for those who are at a very vulnerable time because of some life event, a serious disease, impending death, family tragedy. And I want the very best for them, every best part of the system that we have to offer. But sometimes the perfect is not possible in that care. And those who provide care and service to victims of sexual assault too strive to provide the very best of care. We've heard that today. But data tells us that a large majority of sexual assault survivors have not, for a variety of reasons, had access to the perfect post-assault care. We all wish they could or would. Often they can't or won't. You know, our job as those who seek to provide the very best in our state is to find tools that work. We must constantly be on the search for possibilities that change the deplorable fact that only 1/3 or less of the victims of sexual assault report their assault and get care. We need to examine every avenue and understand what are the benefits, the pitfalls, what's worth keeping, what's worth not keeping. You've heard from survivors and their plea to use self-examination kits. We need to understand their plea and honor it, and if such a kit would possibly have made a difference. We need to know if these kits are a valuable tool for our very, very scanty toolbox. And we need to know the possibility of good and not eliminate that possibility out of the gate before it even gets a chance. We can't always get the perfect, and we cannot let hope for the perfect be the enemy of the good. So my ask is that you open your minds to possibility. As Senator Bragdon said, should we be banning a product that has the potential to empower sexual assault survivors and has been successfully used in other jurisdictions? Or should we first look into this a little more, find a way to have law enforcement, health partners, colleges work together to help bring justice to and empower sexual assault victims? Let's study this concept so we know for real. You have the language for an amendment to that end. I ask that you pass the amendment, to make this into a study committee as part of this omnibus bill. We'll know then, do we actually have the possibility for a new tool?
Senator Hennessy, that's been 3 minutes.
Thank you, Kim. Thank you, Senator.
Thank you. Any questions? I will do my very best to answer.
Senator French.
Thank you, Madam Chair. Thank you, Senator. Is there any danger to the public for allowing this sale of this product?
Well, as you pointed out, Senator French, if you're talking about physical danger,
I am.
we're talking about swabs, paper sheets, things that you and I both probably have in our homes, in our medicine cabinets, in our bathrooms. So in terms of physical danger, of course not. And I think you were rightfully asking, are we talking about a $1,000 fine for selling cotton swabs?
Thank you.
I'd like to ask a question too, if you don't mind. Why? I'm curious about a couple things. One is, if it's just cotton swabs and paper, why can't that be something that is information that's easily disseminated around campuses, et cetera, instead of something that is, getting investors and making money? Why not? If that's really all it is, why isn't there some sort of leaflet or pamphlet that tells people you can collect your own if you think people don't realize that?
Well, I think what Senator French was asking was the question about physical danger. Now, I think, Senator Hennessy, your question is a good one. I think that the opportunity here that we see is in partnership, particularly, let me use your example of college campuses. Picture the situation where a college campus, through their health services, has a supply of self-examination kits. And you have a student who's been sexually assaulted who goes to a trusted student advisor, counselor, who can then counsel them to access through health services to be and instruct them in doing the best collection that they can of evidence. it just opens up possibilities that we could change that data point that says we only have 20 to 30% of people who report this. They get sometimes nothing. And let's change that. Let's see if we can change that at least.
I would just like to follow up my own question with another, and just to say first that I'm really very familiar with sexual assault and sexual assault laws and how it goes on college campuses. I've been very involved for about 40 years in that. And so one of the things that I would say, if anecdotally, I would certainly not say that it's because they don't want to go to a nurse or to a health practitioner or anybody else to get the test, that the reporting is not happening. My own anecdotal evidence is that they're not doing it because they are afraid of the perpetrator and they're afraid of the ramifications of that. So that's just what I'd like to add to what you're saying. But also, my follow-up question is, I have heard that that this Leda Health has in fact had to rename itself in the wake of widespread legal action by state's attorney general. And I wonder if you could speak to that.
Well, I think Madison, who spoke prior to me, could speak to that and give you the actual background. My understanding is that and I will ask that if you would allow Madison to answer that, but my understanding was that people objected to the timing of the Me Too as a, it's a hashtag in many ways. But will you allow Madison to answer that?
Maybe there will be are there other people testifying, Ava?
Yes, there are about 2 other people that I have signed up to speak. And then any individual who we weren't able to get due to technology issues then would have the opportunity to raise their hand.
Okay, great. So rather than having someone come back, in the interest of time, let's see if one of the next couple people has answers to questions. Thank you.
Thanks.
Okay, next we have Jennifer Pierce Weeks.
Good afternoon. Can you hear me?
Yes.
Okay. So I'm going to alter my planned testimony a little bit. For the record, my name is Jennifer Pierce Weeks. I'm one of the Sexual Assault Nurse Examiner Program Directors at the New Hampshire Coalition. And I also am the Chief Executive Officer for the International Association of Forensic Nurses. I've been a registered nurse for 34 years and a sexual assault nurse examiner since 1995. I think there are some really important things for the committee to know about New Hampshire and New Hampshire's response to sexual assault specifically. One critical thing is that any adult sexual assault victim who does go to a health facility, an acute care hospital in New Hampshire, has the option already of choosing to have their evidence collected anonymously and deciding later if they want to make a report to law enforcement, if they haven't made that decision. I think it's really critical that the chair and committee understand that this system has been in place in New Hampshire since before it was a requirement in the Violence Against Women Act. So New Hampshire has a very long history of multidisciplinarily working together to create an effective approach for the medical forensic evaluation of sexual assault patients and making sure that they do not feel like choice is being taken away from them. And in fact, during the exam, if the patient prefers to collect their own evidence in front of the nurse versus having the nurse collect the evidence, they can do that. But the chain of custody is ensured because the nurse either collects the evidence herself or watches the patient collect the evidence themselves. It is that creates the beginning of the chain of custody. The chain is then maintained by making sure it can be tracked from that point of collection through the analysis at the crime lab. in order to get the evidence admitted into the crime lab, even if it's an anonymous case, there has to be a law enforcement connection to hand it over to the crime lab. So for instance, I could show up with an evidence collection kit that I collected as a nurse in New Hampshire and try to hand that kit over to the crime lab, but they would not accept it. They would only accept it from law enforcement personnel, and they would only accept it with a case number attached to it, even if the case is anonymous and no one knows who the victim is except the healthcare provider that provided care. And while some people have testified that there were only 9 certified sexual assault nurse examiners in the state of New Hampshire, there's a difference between
Sorry
nurse
to
examiners.
interrupt. Senator Hennessy, that's been 3 minutes.
Thank you. I'm sorry, but your time has ended. Are there questions? Senator Chanley would like to ask a question, please.
Yes,
Sure.
thank you very much. So I want to understand, you did a very good job explaining the process. I have a good idea. You know, I've heard talk, you know, presentations about this before, but I want to just make sure that I understand this in terms of why do you think it's necessary? What are the advantages of a medical provider doing this testing as opposed? Can you elaborate a little bit more
Sure.
on that? And I think you were tell us about how 9 sane certified nurse examiners are able to
Sure. So
sorry for.
no, it's okay. I appreciate the question. There are more than 60 trained sexual assault nurse examiners in New Hampshire. 25 out of the 26 acute care hospitals have trained sexual assault nurse examiners at them. The thing that an over-the-counter kit, no matter who the manufacturer is, the challenge is that there is no healthcare automatically attached to that. Even though you're hearing about the Monterey, California approach, which has a protocol attached to it and a nurse attached to it, walking the patient through that evidence collection, it's really critical to understand that that nurse cannot testify to the chain of custody being maintained unless they are watching that victim collect that evidence from start to finish on video using a telehealth approach, which means the patient has their genitalia exposed on video for the entire collection process. As a nurse examiner of many years, I don't find that approach trauma-informed in any way when no one can guarantee the admissibility of the evidence at trial, and the sole purpose for the kit is evidence collection. The examination of a patient involves treatment for that patient, connection with community advocacy, and ongoing resources and support so that that patient can recover from their sexual assault and come out on the other side of it with less of the health consequences that we see from sexual assault survivors. That is the true purpose of the exam.
Thank you.
Thank you. See, yeah, did you want to ask another follow-up?
I actually wanted to ask a question of you, and I wanted to get the answer to the question you asked, and I don't know if we're going to have time. It's totally your call. I know as far as whether we could have the person best able to answer that question. I just wanted to mention that.
Well, let's see what we get from them.
Thank you.
I think it's important they know that the kits are freely distributed to all of the hospitals.
Yes, right. Thank you. No more questions? Thank you very much for being there.
Okay, next we have Elizabeth. Again, apologize if I mispronounce the name. Elizabeth Karagosian.
Hi, that's me, and great job with the pronunciation. Thank you.
Getting better.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Dr. Elizabeth Karagosian, and I'm an emergency medicine physician and medical director of the Sexual Assault Nurse Examiner Program at Southern New Hampshire Medical Center in Nashua. I'm also a trained sexual assault forensic examiner myself. I'm here to testify in favor of HB 705, a portion of which is prohibiting the sale of over-the-counter rape test kits. Prohibiting the sale of at-home rape kits in New Hampshire is in the best interest of the victims we serve. I oppose the sale and use of the at-home kits for the following reasons. The kits do not provide access to a trained sexual assault advocate, a service currently available throughout New Hampshire. I happen to be a board member for Bridges and a former president of our local crisis advocacy service, and they are just phenomenal. It's the reason I do what I do. Number two, the kits do not address the patient's health. The health consequences associated with sexual assault are substantial, often including physical injury, pregnancy, STDs, and HIV, just to name a few. Emergency departments in New Hampshire are fully prepared to address these needs, even within the current COVID-19 pandemic. Number three, the New Hampshire Department of Justice provides comprehensive sexual assault kits that mirror the expectations of the New Hampshire Sexual Assault Forensic Exam Protocol to all New Hampshire acute care hospitals and other health facilities that conduct the sexual assault exam. The at-home kits do not contain all the components that a New Hampshire kit would. Number four, there are serious concerns about the admissibility of these kits in the court of law. A, the evidence would be subject to open discovery by defense counsel and likely fall short of many long-standing legal standards for admissibility in a criminal proceeding. B, crime labs may have to place multiple disclaimers on any evidence collected, leading to many courts to deny admissibility. C, even suggesting to victims of sexual violence that they can collect the evidence themselves and have that evidence be admissible in court is neither trauma-informed nor victim-centered. If anything, it leads to victim to believe falsehoods about what can be done with that evidence. It is important to understand that these kits will be sold without benefit of advocacy, nurses, or doctors to actually provide options and care to sexual assault victims, and with a promise of admissibility that simply cannot be truthfully made. Health systems are built to continue their care for all patient populations, even with the pandemic at play. Patients suffering from heart attacks, motor vehicle crashes, gunshot wounds, kidney stones, and serious infections are still being cared for in emergency departments all across the state. This bill will allow the focus to remain on effectively treating patients who have experienced sexual violence and assisting them on their road to recovery. I'm also proud to report my particular hospital has 24/7 coverage for victims of sexual assault and domestic violence, and we do that with 3 anchor nurses, some of whom have been doing it for over a decade. Thank you so much for your time.
Thank you. Are there questions? Senator French.
Thank you, Madam Chair. And thank you for testifying today. Any victim that comes through the system that's in place now, can they get tested without answering any questions?
Well, I will say that victims that come through our emergency department, we have federal regulations called EMTALA. So there is a medical screening process that all victims were required to give through federal law. And of course, one of the things that I'm so privileged to say about the team that I work with is that we do our very best to temper our approach to the victim's individual needs. And I am entirely at their disposal. I will tell them that I work for them. And I am happy to operate on whatever level of minimal information allows me to take care of them safely. We certainly are not trying to impose our agenda onto them. And I think the fact that we can tailor that approach through the years of experience we've had working with this population makes us in a strong position to advocate on their behalf. Thank you for the question, Senator.
So just to follow up.
Sure.
Could you just go over what the minimal amount of questioning these victims would have to answer in order to go through the testing?
So I present everything that I do as options. And if they are interested in the option of the kit collection, then there is routine documentation provided to me by the crime lab. And while it is certainly their option to not answer a question on the crime lab's documentation, I try to inform them that the crime lab will be better able to process their evidence if they allow us to obtain this information. However, It is entirely their choice what they choose to tell me.
Okay, great. Thank you.
Thank you, sir.
And for clarification, the previous speaker, I believe, or maybe it was you, said that you also can do it as Jane Doe or anonymously.
That is correct. We have the option for anonymous collection, which basically means all the evidence collected goes under a unique serial number, which the victim is provided at time of discharge. Their name is nowhere on any of their evidence.
Thank you. And have you actually seen the contents of these kits?
I have not seen the contents of a do-at-home kit.
Okay, thank you very much. Are there
Thank
any
you.
other questions? Seeing none. Is that it for testimony?
It is not. So next we have David Goatsman. Apologies if I mispronounced your name. And then we have another individual from the Department of Justice signed up to speak after David.
Great, thank you.
Welcome. You should be all set, David. Hello? All right. If we are having difficulties, I can move on to Sean Locke from the Department of Justice and then come back to Mr. Goatsman, if that's all right with you, Madam Chair.
Yes.
Super.
Good afternoon. All set? Good. Good afternoon, Madam Chair and members of the Senate Judiciary Committee. Many of you already know me, but my name is Sean Locke. I am an Assistant Attorney General with the Department of Justice. I spent 5 years as a criminal prosecutor and have recently taken on the role of directing the Office's Civil Rights Unit. I am here to testify in particular in support of the incorporation of what was House Bill 1495 into House Bill 705 and the passage of that. The Department of Justice and the Attorney General strongly support this legislation banning the sale of over-the-counter rape test kits. The sale and use of over-the-counter rape test kits greatly jeopardizes the investigation and prosecution of sexual assaults. I cannot think of a single trial court in the state of New Hampshire or any context in which a trial court would admit evidence gathered with the assistance of such a kit. There would be questions related to the chain of custody. What became of that evidence after it was gathered before it arrived in the courtroom for presentation? There would be questions of tampering with that evidence. And the victims who would be trying to introduce that evidence, assuming it even got that far, would be subject to withering scrutiny by defense counsel and likely allegations of falsification. If we were in person, I would have with me a sample of an actual rape test kit used by sexual assault nurse examiners in the state of New Hampshire. These are produced by the Department of, or through a contract, but by the Department of Justice. They include access information regarding resources available to victims of sexual assault. And the gathering of such evidence can be a very involved process in the sense of not just taking evidence from the person's physical body, but also it may be gathering articles of clothing, bed sheets, portions of fabric from a motor vehicle. It depends on wherever the sexual assault occurred. It could include gathering blood or urine samples if there are allegations of a person being drugged or impaired. These are things that would have to be stored in safe, kind of bio-safe facilities. So whether that includes climate control and records of access to preserve that evidence for the time until it would be ready for use and demonstration and testing during trial. I am happy to take any questions regarding this, but the prime point of this testimony is to kind of highlight the fact that as a prosecutor, I do not see a way in which one of these kits or evidence gathered from these kits could be admitted in a court, and it would jeopardize, as I said, investigation and prosecution of sexual assaults. And that is, as Senator French had asked several times, that is the danger here that this law is trying to prevent. A false hope that gathering this evidence would allow it to be used later on, whether it's in a civil case or a criminal case, to vindicate for a victim to seek justice. That is the danger here, that would not happen and that these kits would prohibit or block that from occurring.
Thank you very much for your testimony. Are there questions? Senator French.
Sorry, Madam Chair, I'm just trying to figure this out. Wouldn't it be better to have something than nothing, however, where some victims would possibly use this kit and have something versus not go for any testing whatsoever?
Well, so the issue would be this, but the problem with this kit is that the problem with this kit is the admissibility and the use of this evidence and the kind of the false hope that it creates is that this evidence, if you gather it, you could use it in trial to prove that you were sexually assaulted. That's not the case. The rules of evidence, the chain of custody, the right to confront, I mean, there would be multiple challenges that could be raised to any of these kits, and certainly in a criminal case and very likely in a civil case, that would prevent any evidence gathering from being admitted. The opportunity to gather that evidence comes from going and having a sexual assault examination that occurs after the sexual assault happens.
Would you like a follow-up?
Just a quick statement. We heard Monica Lewinsky's blue dress did have a benefit to Monica Lewinsky.
Well, and that's in a different context though. That was not a criminal proceeding, that was not a civil proceeding. That was a bit more in kind of the court of public opinion, the impact of that dress versus an actual court where evidence was gathered and an adjudication by either a judge or jury was made.
And maybe that's all someone would want.
That may be the case, but the way some of these kits are being billed is this is kind of a gather your own evidence for trial kit.
I can understand the problem with that. Thank you.
If no one else has a question, I'd just like to, I guess, reiterate, thank you for your testimony. And would you be at all surprised if I told you that the public defenders I've spoken with about this have said that it would be a boon to them because these tests would be, they're obviously defending the accused, and they would just be seen as inadmissible, and so it would actually make their lives easier.
I would not be surprised by that, and I think that's the premise that we've been operating under in supporting this legislation as it went through the House.
Thank you very much. Are there further questions? In the interest of time, I think I'm going to drop the question that I asked about the lawsuits, and because we really do have a lot on our docket today. So we're going to move on. Thank you, Ava.
Of course. So next we have David Gottesman. You should be unmuted. Okay. Madam Chair, as you can tell, there's no audio. I see that they've unmuted themselves, but
I see that too. Should we ask that the person call in and do a star?
Sure. I mean, I did see this person's name twice on the attendees list, and now it's back to one, but unfortunately, there's not much I can do further as the host.
So, Mr. Gottesman, if you could perhaps call in, and can you give the explanation again, Ava, of how that would work for him?
So I see him on my attendees list and I've permitted him to speak. However, it appears on my end that he's unmuted, but there's obviously no audio. So if he is calling in from a phone or wants to call in from a phone and dial *9, I can find him that way. But other than that, there's not much else I can do as the host of the Zoom at this time.
Okay,
I will resend his confirmation credentials so that he can try to relog in right now.
Okay, I just got a text from someone saying that he does not have internet service at the moment.
Well, then that explains it. So in the interim, we did have hands raised. There is one hand raised. It is an individual that has previously spoken. So you just let me know, Madam Chair, how you'd like to move forward with that.
Is this a hand raised to ask a question?
That's a good question. It's Haroon Chima and Madison Campbell. It may be very well that they were attempting to respond to the question that you no longer proposed, but there are multiple hands raised.
Jenny, we can't hear you.
Sorry, I just saw the phone number hand raised and I wasn't sure if that was Mr. Gottsman calling in, maybe.
Let me just take a peek here. It is. So I will add.
Thank you so much for your patience. I apologize for my connection, but Madam Chair and members of the committee, I appreciate your taking my call and your patience. I just wanted to weigh in on House Bill 705 with the amendment, especially in light of the fact that I have had an opportunity to represent many people who have been sexually assaulted, both as children and as adults. And many times the children do not really recognize this, I think, as the statistics show, until they are in their 40s or 50s. And it is critical that we allow them to have their day in court and to make these claims over this dreadful behavior. You have heard most everything else that I would have said, so I don't want to delay your hearing. I do appreciate all of your work. I did sit on that committee at one point in time and know how hard it is to make these decisions. Thank you very much.
Okay, so
So at this time, I have no one else signed up to speak. The only hand raised at this moment is Haroon Chima. And then that.
okay, since that is somebody speaking again, I think we should just as long as it's one, let's limit the time, but let's go ahead. I'm just very cognizant. We have a lot to do.
Absolutely. So Haroon Chima, you should be unmuted.
Sure. Thank you very much for this opportunity, and I'll keep my comments brief. We've heard a number of people talk about admissibility. This is inadmissible. It won't be admissible. This is not a legislative call. This is not something you can legislate. This decision on admissibility, inadmissibility is done by a judge during a court proceeding. It is a question of fact, not a question of law. By trying to legislate rules of admissibility, you are violating the separation of powers and you are denying due process. If you were to make all of this evidence automatically admissible, you would be violating the due process of defendants. If you were to outright make it all inadmissible, you would be violating the due process of victims. The way to resolve this is to get in front of a judge and have an evidentiary hearing on the merits, not by statute. Thank you for your time.
Thank you for repeating your previous testimony. I also wanted to say that I don't personally, as chair, believe that anybody on this committee is trying to decide about admissibility. You're correct, that is not our job, but it is our job to protect our citizens, and that's why admissibility is an issue. But thank you. Is that the end of the testimony? So unless anyone else had a question? Yeah.
One more person just now raised their hand. So multiple actually. So Madam just raised their hand. Oh, I'm sorry, Madam Chair.
I was going to say, this is what I was afraid of.
Senator Hennessy, I think that it's not appropriate for us to engage in a back and forth, especially repeating testimony that's already been stated. So I think that we have another hearing to hear. If Ms. Campbell has testimony that she feels like is vital, she can email it to the committee. I know we're planning on breaking to review amendments anyway, and the committee would have the opportunity at that time to review any testimony that she wanted to submit.
Brilliant. I think that's correct. We do really need to move on.
So, and that is all I have.
Is that. So at this time, I'm going to close the hearing on House Bill 705. And what I believe is going to happen next, this is all a little dodgy to me,
So
but,
Tennessee.
oh no, we're going to do the bill.
Well, yep. So if you want to, we can hear the bill first. We did receive the latest amendment that's been submitted to the committee members via email earlier, and it is available online. But if you wanted to do the hearing on the bill itself first and then recess for time to review, that's totally up to you.
Apologies, that was my intent actually, and I got confused. Okay. Okay, so I would like to open the hearing at this point on House Bill 1645 and ask if Representative Abbas is here to introduce it.
Yes. Representative Abbas, you should be all set.
Good afternoon.
Good afternoon.
You guys can all hear me. Good afternoon. Thank you for taking time to hear me testify today. Under the current law, a person who's been convicted of a misdemeanor domestic violence charge is eligible for an annulment after 3 years. The original version of this bill was very clear, would just extend that to 10 years, but what it would also do, it would prevent someone from getting an annulment if they had multiple convictions unless the most recent conviction was eligible for an annulment. And I took some of that idea, I was taken out of what was originally Senate Bill 311 from 2019. That part, through the debates that we had in the House, we took that out. And I just wanted to say that I think this bill should pass. I thought Senate Bill 311 had some unintended consequences. Excuse me. Where a person would be eligible to get an annulment before they actually paid the restitution to the victim. And that created maybe an unintended perception. So what we did was we took that out and it was in the Criminal Justice Public Safety Committee, but I made it a point to then take the good part, at least the part that I thought was great, and put that forward. And I think considering that this type of crime is something that is often repeated, where in both a victim and a criminal often repeats the crime, I think it's important to not show leniency for these types of crimes. And there are also crimes that tend to escalate over time. So with that, I did go through some of the amendments, and I will say that I kind of have a conflict with one of the amendments, so that's why I'm not testifying in regards to the amendment. So I hope this takes this into consideration and passes it. And if you have any questions, I'll be happy to answer them.
Thank you. Does anyone have questions for Representative Abbas? Seeing none, we can go on and hear those wishing to testify.
So actually, Senator, Madam Chair, Representative Cushing has his hand raised. So.
Oh, great.
Thank you, Madam Chair. Members of the committee, for the record, I'm Representative Rennie Cushing. I just want to echo Representative Abbas's comments about the bill. I just would note that this passed the Criminal Justice and Public Safety Committee 18-2 and passed the House on consent. I would urge your support, and I'll speak to the amendment when the amendment comes up. Thank you.
Thank you. Is there anybody else who would like to speak?
Yes. So Rory McDonald has signed up to speak to the bill. It appears they're muted on their end. Rory, if you are having difficulties and if you're calling in via phone, please feel free to dial *9 and we can try and connect you that way. In the meantime, Madam Chair, do you want me to just go to the next and we can try and get Rory at another time? Sure. Next, we have Aphrodite Michael Katulis.
Hi there, I'm just listening in. You can go on to the next caller. Thank you.
Sure. Okay.
Madam Chair, if I might, I just want to make note that my internet is giving me a bit of trouble. So I have moved. I'm in a different room in my house, and there may be my young adult children and husband wandering through. I just want to make that clear.
Thank you.
Okay, next we have Catherine Cooper signed up to speak to the bill.
Thank you, Madam Chairman and members of the committee. Catherine Cooper here on behalf of the New Hampshire Association of Criminal Defense Lawyers, and we oppose this bill. Our government has decided that annulment is an appropriate part of the criminal justice system, and in our view, we should not be parsing out and categorizing crimes that have no significant difference in severity. You will see some examples in our written testimony of low-level conduct that would still be captured by this bill. Making this change will impact the number of cases that go to trial and likely require additional litigation. I've heard from several of our members that they have concerns about this bill because there are already a great deal of difficult cases where attorneys make the analysis that the client will likely be found guilty at trial, but the client is very reluctant to plead guilty to these charges because of the collateral consequences, one of which being the access to guns. We have a significant culture in New Hampshire where people use firearms recreationally and feel that they're important in their lives. And it's already difficult to get people to do any kind of a plea to a charge like this because of the ban that takes place as a result, even when the charge has nothing to do with firearms. So that's a significant concern. Basically, we already have in place systems to weed out cases where annulment is inappropriate. Prosecutors routinely object to annulment on different cases when they think that it's a serious and significant misdemeanor crime, and judges routinely deny annulment. So we think that the systems in place and the policies that we have right now are sufficient for dealing with these misdemeanor level offenses. And we do have some additional information in the written testimony, but I'll suffice with this now for my oral testimony. Thank you.
Are there questions? Seeing none. We go on to the next person testifying.
Sure. So briefly before the next on our list, Representative Abbas has his hand raised.
Oh, okay. Hello.
Hi, thank you very much, Representative Abbas speaking again. Would it be all right if I commented on the issue of firearms and how this bill relates to it? I know I finished my testimony, but would it be out of order if I did that?
I think that's okay. Go ahead.
So it's my first term as a state representative out of Salem, which is Rockingham County District 8, and based on my voting record, some people may appreciate this, some may not, but I have a reputation of being very strongly supporting the Second Amendment, and I am or some say pro 2A as they come. And I'm the prime sponsor of HB 1645, and I'm well aware of how this will impact an individual's rights to purchase firearms. And with that being said, that was something I put into consideration when this bill went forward. I understand that someone convicted of a misdemeanor domestic violence may have to wait 10 years instead of 3, but that's just the reality of the situation. This is a violent crime, and these crimes tend to escalate, and as they escalate, they get more deadly and dangerous every time. So that was something that was thought about when this was filed. Thank you.
Thank you. And we can go on to the next.
Sure. So the next we have signed up to speak is Jane Mason. However, I no longer see Jane on our attendees list. So if she is calling in, she can feel free to dial *9 and raise her hand that way. In the interim, the next and last speaker we have signed up is John Skippa.
Thank you.
You're welcome. It appears, you all set.
Madam Chair and members of the committee, thank you very much. My name is John Skippa. I am the newly appointed director to New Hampshire Police Standards and Training Council. And just to give you a little bit of background about myself, I was not born here, but raised here in New Hampshire, attended high school in New Hampshire here in Londonderry, attended college across the street at New Hampshire Technical Institute and UNH. Did travel out of state for my master's degree, but I came right back. I've spent 29 years in New Hampshire law enforcement as a full-time police officer. And my last assignment was chief of the Stratham, New Hampshire Police Department. I am very thankful today to the committee to hear me. This is the very first time that I've spoken in front of the committee or any legislative body for that matter. So please bear with me. Specifically, there are two pieces to the legislation put forth that I wanted to speak to.
Can I just interrupt you for 1 minute? I want to be sure you're speaking to the bill 705 and not to the amendment.
I'm sorry, Madam, I am ready to speak to the amendment, I believe, if I'm figuring it out.
That's what I thought, and we will certainly give you a chance to do that when we get to the amendment.
Thank you, Madam Chair.
No problem at all. Thank you. Okay, so did we hear anything back from the person who couldn't get in or wasn't on the list?
Jane Mason is still not on my list that I see. Rory McDonald is still on the list. I can try and allow her to speak one more time. That was the individual who had technical difficulties, but.
Oh, okay.
Are you able to join?
Hi. Sorry, I didn't need to speak on this topic. I appreciate it. Thank you.
In that case, we will close the hearing on House Bill. I always have to look at it so I know what the numbers are. 16. Oh, I thought 1645. We're going to close the hearing on House Bill 1645. And I would like to suggest that we have a brief recess at this time. I think we've all been sitting here for long enough that we may need a personal health as well as, hydrating ourselves, etc. So I'd like to ask for a 5-minute recess. Thank you.
Hey, what did I miss?
Senator French, we are in recess, so everybody's on mute right now.
I just come back from recess.
Yeah. Oh, well, you were checking the weather, Senator.
I
so-
was. It's very nice out.
Oh, good, good.
Okay, I'll be back. What
All
is
right,
it, 5
5
minutes?
5 minutes. So we just started. Okay. Senator, were you saying something?
Yeah, sorry, I was just saying the 5 minutes is up, so I'm hoping people will come back. And Jenny, I'm hoping you are prepared to help me through this next.
Kim, you utilized your recess very well with the tea.
Did.
I've outsourced my beverages, so that'll be coming
So
soon.
I bought an electric kettle recently, and so I
I
feel
love
the
an
need to
electric
use it
kettle.
more. And so 5 minutes is how long it takes to boil water. So I
Bravo.
There you go.
Yeah.
All right, so Senator, I think, like I said before, I think the amendment is up online and good to go. It's 1455S.
Yes.
So you'll introduce the original amendment
I shall.
and then go ahead into the new one.
That's right.
Jenny, before we get started, are there any amendments for 1645?
So just the one that I sent, 1455, that I
There's
sent.
nothing else.
Not that I'm aware of in writing. I'm sure
Okay.
there will be discussion amongst the committee members regarding how to package the language at the end.
Okay, I just want to make sure because I keep getting email about additional language and I haven't seen it, so.
Yeah, I think that, like I said, I think there's going to be discussion regarding how to do the language at the very end during executive session, but this is the only written language we have at this point in time.
Okay,
Okay, thank you. So I will open the hearing on the amendment 1455S to House Bill 1645. So, and I will read the title of the amendment, and as Jenny said, it is available online. Is that right? An act relative to Superior Court judgments, adding a bail commissioner to the Commission on Pretrial Detention, pretrial scheduling, and pretrial services, and the release of a defendant pending trial, prison privatization, misdemeanor domestic violence offenses, immunity from arrest or prosecution for certain alcoholic beverages violations, police officers reporting misconduct, criminal mischief, and screening for all law enforcement officers for psychological ability prior to assuming their duties as certified officers. The bill incorporates into 1455 the following. The amendment, I'm sorry. The bills are Senate Bill 755 relative to Superior Court judgments and actions against the state, Senate Bill 551, adding a bail commissioner to the Commission on Pretrial Detention, pretrial scheduling, and pretrial services, and relative to the release of a defendant pending trial. House Bill 1272 prohibiting prison privatization. House Bill 1645 relative to the annulment of misdemeanor domestic violence offenses. Senate Bill 722 relative to the payment and education of bail commissioners relative to criteria for determining an offender's indigence and establishing a committee to study providing remote access to a bail commissioner's services. House Bill 1351 relative to immunity from arrest for prosecution for certain alcoholic beverage violations for a person under 21 years of age who reports a situation involving risk of alcohol overdose. House Bill 1217 requiring police officers to report misconduct. House Bill 1468 relative to criminal mischief. And House Bill 1174, which was added since the last amendment, requiring screening for all law enforcement officers for psychological stability prior to assuming their duties as certified officers. And has everybody have been able to find the amendment?
Sorry, Senator, to interrupt. So we're apparently having a bit of an IT problem getting it up online. So
Okay.
Alan's going to put it up on the screen share for everybody to see. It's the same amendment the committee members already have, though, and you can continue discussion from
Okay. Okay, thanks. So we're ready to call members of the public to speak. On amendment 1455, which is now on the screen.
So first we have Representative Cushing. You all set, Representative?
Thank you, Ms. Hawks. For the record, I'm Representative Rennie Cushing, and I'm going to testify in support of this amendment. I have not had a chance to read the final iteration, but I've read the early one, and I'll comment on a number of pieces. Primarily, I want to speak upon the component bills that passed through the House Criminal Justice and Public Safety Committee. I'll start with HB 1272, prohibit prison privatization. This bill came before our committee. It ended up passing 20-0. There was an amendment that was originally requested by was supported by the Commissioner of Corrections after an amendment that she requested was included that clarified in emergency situations, the authorization was there to transfer prisoners on a limited basis to private out of state or public out of state in places. We also, during the course of the hearing, heard from the superintendents of the departments of corrections, which also wanted a similar provision, and we included that, the proviso being that the authority that oversaw that for the county level would be the county commissioners. The next bill we had was House Bill 1645, which of course we already addressed. House Bill 1351 is relative to immunity from prosecution. Again, this passed our committee unanimously. This was recognizing that there are instances where acute alcohol poisoning can take place, and we want to provide for a good Samaritan provision to save lives. So this allows an individual who is calling for help for an alcohol overdose, who him or herself may have been illegally consuming alcohol, but for that person who makes the call, that they are exempt from prosecution from that. It's akin to what we have done and what the Senate Judiciary Committee has also done with drug overdoses. The next one is House Bill 1217, requiring police officers to report misconduct. Again, this was supported by the Criminal Justice Committee. I can't remember, I believe pretty unanimously. It's simply a duty to report as a mandatory reporting. It's akin to what we have for people who see child abuse or see other examples, people in authority who have a responsibility that's above and beyond just what an individual citizen does. But this requires someone to be a mandatory reporting. In this instance, it requires law enforcement who witness misconduct on the part of other law enforcement to make a report on that. I believe this probably, I think we're aware there's a certain timeliness of this particular amendment given recent events that have taken place nationally that I think have reverberated throughout our country and also have reverberated here. House Bill 1468 that expands the criminal mischief to try to protect some of our public facilities and statutes. This arose out of a concern about some some mischief that might not rise to the level of vandalism, but because it was not permanent, but it had a temporary negative impact upon public properties. And this was a bill simply to kind of capture that under the current criminal mischief statute. And finally, I have not seen it, but House Bill 1174, that was a recommendation from the House that arose from a performance audit that was done by the LBA through the Police Standards and Training Council last year, that identified a problem in the state, and that while there's a requirement that members of law enforcement must be certified, in order to be certified, must pass a drug and a psychological fitness screening test. when the legislature established that requirement in 1997, it had a little proviso that we would require that unless a local community decided that it didn't want to pay for it. And our committee came to the conclusion, in following the recommendation of the audit and the recommendation of the Police Standards and Training Council itself, that it was time that we have a uniform system of certification and qualification to be law enforcement officers in the state of New Hampshire, and that the idea that we make state laws that are that are uniform in every jurisdiction, and the idea that we might have some jurisdictions we would have members of law enforcement who had not even passed a psychological fitness test out operating and enforcing the laws of the state. We did not believe that there should be this unequal system of law enforcement. So we made a recommendation to, so that's when we passed House Bill 1174, that's what we intended to do. It's my understanding, again, I haven't seen the amendment, but it's my understanding that the amendment that is being brought forward does not address what we proposed as a funding mechanism, but instead simply simply removes the exemption for some communities to opt out of this kind of uniform standard. And I note that I know the members of my committee, and I believe members of the Senate Judiciary Committee have reviewed the audit as well. I mean, I think we were shocked to find out that, in some instances up to, there are, I believe 30% of some law enforcement agencies had people who had either not undergone either a psychological fitness test or a drug test. And, that's just untenable. That's pretty untenable. I do know that Mr. Skippa is, I'm not sure if he's going to testify, and I haven't had the chance to testify or consult with him. I want to welcome him aboard to the stewardship over the Police Standards and Training Council. But again, this is something that we've identified, and in the state of New Hampshire, it seems crucial that we have a commitment that those who are charged with enforcing the laws of the state, who are given the authority to carry firearms, to use deadly force, and that they meet the high standards of physical and mental readiness and stability for their jobs. So with that, those are the components of the bill that I'm familiar with, and I recommend, and I thank the Senate for incorporating them into this.
Thank you, Representative. I neglected to say earlier that I think maybe it would be a good thing for me to just outline some of the changes, because I'm not sure everyone can see the whole bill. And I wanted to say that in 1174, which is the bill that Representative Cushing was just speaking about, this principally adds funding, as he was saying. It does not change. It does not change the function of the bill. And the criminal mischief bill is as it was originally written, with the exception that they removed the word covering, meaning that if you put a blanket over something, that is different. This is my interpretation than actually degrading it in some way or debasing it in some way. Bail form section 4 reflects the agreement of the bipartisan pretrial detention commission, who did incredible work to get that done. Those are the major differences in 1455 for the committee and others to know. Okay, thank you. I got my piece in, and we can go on. Are there any questions for Representative Cushing? I don't see any, but I can only see part of the.
Is it possible to download the amendment at all?
That's a good question. I know that the Senate staff on this call are working with IT to get this uploaded on the website. I don't believe it's happened just yet, but I know that there are people working.
Ava, could somebody just email it to me?
Sure. The amendment that we're screen sharing, Representative?
Yes, this one, whatever iteration it is. That doesn't have a number on it, just says, oh, it's got a 1455S.
Correct.
Just so I could.
Let me see my hand.
Representative Cushing, if you were to go to the state website, go to the general court where they give you the information about the hearing today, you can download a copy of amendment number 1455S there.
Okay, I tried doing that earlier then. Thank you.
Okay.
So regrettably, we are having some technical issues with getting 1455 up, and as soon as it is up there, I'll make sure that we let it know, everyone know. Representative Cushing, I just send it to your personal and legislative email.
Thank you very much, Jenny.
Super. And Senator LeVake has her hand raised.
Thank you. I wasn't sure if you saw me, but thank you, Ava. Thank you, Madam Chair, and thank you, Representative Cushing. I have a question on 1174. Was it your original intent to have the standards council pay for the training?
Yeah, in response to that, it was an amendment that we developed initially. There was a question that was raised about where the money is going to come from. So based upon the information that was provided to us by the Police Standards and Training Council, it would cost about $94,000 a year would cover the expenses of the psychological screening tests for candidates for certification. So I rounded that, the rounding was from $94,000 to $100,000. And then we went to the drug forfeiture funds, which had a surplus in it, and took the first $100,000 off that under the theory that every candidate who is going to be enforcing the drug laws of the state should be qualified and pass that test, and put that money and gave that to put that into a fund that would be administered by the Police Standards and Training Council that would then be used to pay for the tests. So that was the proposal we have. And again, I've not seen the latest iteration of the amendment that we're dealing with. If that's the amendment, that's what we sent 11. That's how we sent 1174 to the Senate.
Madam Chair, I have a question. Thank you. Thank you, Madam Chair. And
apparently Senator LeVake had a follow-up. I apologize.
Okay, that's all right.
Sorry,
I'll
thank
wait.
you. Thank you, Madam Chair, and thank you, Representative Cushing. When you say 94,000 per year, is that for all the trainings, or is it just for the folks that can't pay for the training?
It is just for the folks that right now have said they can't or don't want to pay to have their officers tested for psychological stability.
Follow up? If the Police Standards and Training Council is responsible for ensuring that that these officers are trained, including psychological training, why can't we put more onus on them and each individual town to pay for the training? And just to let you know, I'm all in favor of the training. My concern is that when we take funds away from the drug forfeiture fund, we're taking it away from the larger cities that actually need that money for programs.
Thank you for your question, Senator. And I agree completely that I believe that this is an expense that that appropriately should be paid for as part of the Police Standards and Training Council certification process. I recognize that we have a situation now where some cities do it. My community pays for it. Your community pays for it. And yet there are other communities that are not paying for it. My concern I just was trying to figure out a way to get this to be a uniform policy and to pay for it. So I think in an ideal world, certainly let's take it out of the general fund. In an ideal world, let's take it out of a more appropriate one. I had there were no end of suggestions that I heard. No, there are a number of suggestions I heard as to where one might find the money. I don't think that we need to provide the money to make the policy. I mean, let the communities find it out. Or, I mean, there's a number of suggestions I have. It's about $400 to $500 for a test. I will tell you, I had conversations. I don't understand why Primex, I don't understand why the insurance industry doesn't step up, because certainly if you're a community and you want to engage in best practices, if you don't engage in best practices and you have someone who is not qualified, who goes out and is, derelict in their responsibilities, and there ends up being a lawsuit, that can be ultimately that's a poor investment. And I know a lot of people say, well, we have qualified immunity, so we don't actually have to worry if we send our law enforcement out there and they do something wrong. I think that's unacceptable too for us to take that position.
Okay, thank you.
Thank you. Now, Senator Carson.
Oh, sorry, Senator Kirsten. Number one, you're muted, but just really quickly, we're really sorry about the delay. The amendment is now up on the general court website for anybody that's looking to access it.
Good. Thank you.
Okay, there we go. All right, I've unmuted myself. Thank you for taking my question, Representative. I am also concerned about the funding source for this. The drug forfeiture fund isn't what I would call a stable fund because it varies from year to year. And I think if we're going to put something like this into statute, that we need to have a stable funding source, because I can imagine not enough money getting into this fund, and police standards and training are going to come to finance and start asking for more money as this goes along. So I'm wondering if, I know you had said you thought about other sources, but I really do believe we need a very stable funding source for this. Have you thought about any other kind of funding source for this other than just the drug forfeiture fund, which I believe to be a little controversial considering the number of pieces of legislation Judiciary has seen over the past 5 years concerning the drug forfeiture fund?
Well, thank you for your question, Senator. I mean, I think the general fund is an obvious answer from my perspective. I think it's it's core government function to provide police and public safety. That having been said, people suggested, do you want to look at the penalty assessment fund? Well, that's, we already dealing with, that's 24%. That's pretty high. I don't know, there's just other places we could suggest looking. I realize that what you have before us is what we came up with and we sent, and I certainly would be amenable to, if the Senate wishes to find another source or incorporate or direct some other funds to come from it. It could come from 712 funds, as far as I'm concerned. It's essentially the same kind of I think it's an emergency situation for us not to have law enforcement officers, certified law enforcement officers in the state of New Hampshire that we know have passed psychological stability screening tests. That's the best I can answer you, Senator.
I'm just going to jump in here too and say that the current way that the bill is written for funding is until the next budget is written, at which time the funding will be written into the budget.
And thank you very much, Senator. As I said, I'd had, past several days, several weeks, lots of conversations about lots of pieces of legislation, about trying to address these different concerns. And I had not seen the latest iteration from whatever suggestions had been circulating around. I was told that that there would be an iteration of the bill that would get before you. So.
Yep. Well, thank you. I know we've all been trying to keep up with it all. It's tough.
And I trust this. I know that you'll figure it out.
Yeah. Are there further questions? Senator Chanley has a question for you.
Senator Chanley, you're muted. So sorry.
I try to do that for the benefit of everyone, but thank you. And you basically answered my question, Senator Hennessy. I was going to ask Representative Cushing that, you know, I share some of the concerns that have been raised about how we're going to fund this right now. But if we don't have a funding mechanism now, it would be hard to pass this because we are then, it's policy without funding. But I do think it's fair to say that we will be, the legislature that is elected in November will be convening in January and setting forth on work on a budget. And this issue will certainly be there. And I think it'll be made all the more strong if we include this in the budget, in the amendment today. Thank you.
Are there any further questions from the committee? Seeing none, we thank you very much again. We've kept you busy today, Representative Cushing.
It's always a joy to be before Senate Judiciary.
Thank you. It's always a joy to have House Judiciary and Criminal Justice Committees in front of us. So we will move on to whoever's next on the list.
Perfect. So next is Lynn Shullett.
Good afternoon again. Thank you, Madam Chairman and members of the committee. My name is Lynn Shullett. For the record, I'm the Executive Director of the New Hampshire Coalition Against Domestic and Sexual Violence, and I am speaking just to the language that was the prior House Bill 1645, or Section 1, that addresses annulments of domestic violence crimes. As you all know, when a crime is annulled, it means that there is no information that's available any longer about that underlying conviction. The Coalition's concern is that this is problematic because of the nature of domestic violence specifically, and the fact that information about patterned domestic violence crimes can help promote safety, both for individual victims, but also in our larger communities. What we know about domestic violence is that it's a unique crime. More than half of the homicides and 80% of the murder-suicides in New Hampshire are linked to domestic violence. When we think about mass shootings, what we often think about is big public places, stadiums, and outdoor venues. But the reality is that half of the mass shootings in the United States actually include domestic violence. Domestic violence, more than any other crime, also represents a heightened risk for escalated violence. Bar fights, fights between strangers don't often escalate, but what we do know is that violence between people who are related to each other or share a household often escalates. And lastly, domestic violence is dangerous not only for victims, but for the people who respond to domestic violence cases, whether that's law enforcement officers or social service providers. They are far more likely to be injured when responding to a domestic violence case than to other kinds of crimes. Recognizing all of these dangerousness factors, New Hampshire law enforcement has adopted the lethality assessment program, which is a simple questionnaire that law enforcement officers, when responding to a domestic violence case, ask a victim. 11 questions. Depending on the score on those questions, the law enforcement officer can connect the victim immediately to crisis center services. So it's really important, it's imperative that law enforcement have access to information about offenders' past. So this amendment is vital to give law enforcement and communities the information they need to help residents in New Hampshire stay safe. And we ask for your support. Thank you so much.
There are questions. I have a quick question. I wondered if you would be able to tell, you know this is about misdemeanor domestic violence, I'm sure. And I'm wondering if you could tell me the difference between misdemeanor and what violence and other charges.
I don't have the statute right here in front of me, but obviously the gradations are going to be the level of severity that's involved with a felony versus a misdemeanor. I think what's important to know about domestic violence cases, and I know you're familiar with this, Senator Hennessy, is what we often see in domestic violence cases is not only are they charged as misdemeanors, but they so often are also pled down. More serious crimes, higher level offenses are very often pled down to lower level misdemeanor offenses.
Thank you. No further questions? So we will move on.
Next, we have Daniel May. Let's see here. You should be.
Can everybody hear me? Hello?
Oh, that's
we can now. Yes.
You can hear me? Yes. Hello?
There's a slight technical
Delay.
difficulty. Yes, delay.
I can understand it.
Okay. Can I change rooms and then go back? Because it's something weird in my house right now with the Wi-Fi.
We hear you perfectly now, actually.
Okay, perfect. How about now?
Yes.
Okay. Madam Chairwoman and members of the committee, my name is Daniel May, and I'm a concerned citizen of New Hampshire. As a Black male, I have personally experienced crimes against my person and violations of my rights by the local police department in my town. I've been assaulted and harassed, targeted, and called many horrendous names, which I will not repeat here. Illegal search and seizure, false documentation, evidence loss, as well as personal violations, physical and verbal, have occurred repeatedly towards myself and others in our cases. The negativity that has reflected throughout the community due to the mismanagement of my cases and others in my area has made it extremely difficult for our citizens to trust the police, who are meant to protect and serve our best interests. People are afraid to walk the streets day and night. And it has come to the point where my town has been gentrified due to the police systemically harassing and abusing minorities. The police are feared and not revered. And this has turned into insanity that has reverberated around this whole country. And it is my belief that there are good police officers who want to stand for true justice, not some code passed down to them by some poisoned doctrine. And after police hold each other accountable like other professionals do, then the trust may come back for them in the community. The accountability needed is if you see something that is illegal and unjust that your colleague is doing while you're a police officer, that you should say something, that you report it and make sure it is tried to the furthest extent of the law, which I believe is true justice. Once everyone is on the same playing field in regards to human rights, that is when we can make the changes necessary to heal the citizenship. This is why I stand behind this amendment today with my full support. And I thank you all for your time and your hard work and dedication to the members of your community. Yeah.
Are there questions?
Thank you.
I don't see any questions. Thank you for your testimony.
Okay, next we have Michael Donnelly.
Can you guys hear me?
Yes.
Okay. Good afternoon to all in attendance. Hi, my name is Michael Donnelly. I live in Antrim, New Hampshire, and I'm here to support the amendment to this amendment for the simple fact that the officers we appoint to uphold our Constitution should be held accountable on a higher level than the average citizen. Mandatory reporting has been a thing for years, and I guess I expected that police officers kind of, police officers holding other police officers accountable was kind of just wrapped right into mandatory reporting. I kind of figured that was all the case. Here's that I was wrong. However, in my mind, to protect and serve means precisely that, to protect and serve the constituents who have entrusted their safety to law enforcement, even if that means protecting those constituents from officers of the law who see their badge as a free-for-all license as opposed to a sacred bond of trust between them and the citizenry. Having lived in New Hampshire my entire life as a man of color, I have been subject to a few encounters in which if an officer had spoken up about another's misconduct, I would have more faith in law enforcement than I do today. With that being said, I stand in firm support of this amendment. Here in 2020, transparency is a necessity, and supporting this amendment is the next logical step. We are repeatedly told, if you see something, say something. This should apply to all members of this country, not just some and not others. Thank you for your time.
Thank you. Are there questions for Michael Donnelly? I see none.
Okay, so next on our list of individuals signed up to speak is supposed to be Trixie Lefrave. However, she's no longer on our attendees list. So if she is calling in, please feel free to dial *9 and that'll virtually raise your hand. Or if you're on Zoom via the internet, please feel free to raise your hand. In the meantime, we will go to the next person signed up to speak, which is Joseph Lescaze.
Yep, that's good. Anyway. Let's start. Thank you. Thank you, Madam Chairman and members of this committee for hearing my testimony today. My name is Joseph Lescaz, and I'm the Smart Justice Organizer for the ACLU of New Hampshire. Rather than speaking from my professional role with the ACLU, though, I'm here to speak from my personal experience as a Black man, a constituent, and a concerned community member. I'm sure everyone that's on this call can say that they have suffered an injustice at some point in time in their life. And as a Black man that was born and raised here in New Hampshire, I've personally experienced injustices in some of my interactions with New Hampshire law enforcement. And it wasn't the injustices that I suffered that had the most impact on me, but rather the lack of other law enforcement agents standing up for what was right in that moment and holding their coworkers accountable for the injustices that were being perpetuated. My personal experiences what have led me to my concerns as a New Hampshire resident. And one of my top concerns is the rapidly dissolving community trust in law enforcement, as well as the lack of transparency around how law enforcement handles unfortunate instances of police misconduct. We're in a time period where more than ever, we need to repair the trust between marginalized community members and law enforcement. And that type of trust, faith, and healing is directly tied to accountability and the idea that there are policies in place which will hold our civil servants accountable for their actions. In my professional role, I've spoken to law enforcement personnel who have told me that this proposed amendment is a great idea and should have been instituted a long time ago. I asked them to testify today about their belief in this amendment, and I was told by both of them that they couldn't for, and I quote, obvious reasons. And I think that point needs to be highlighted. Why does it seem that officers can't come forward and testify or speak openly in support of law enforcement accountability? I want to be explicitly clear on this. I am not saying law enforcement is bad or all police are bad apples. I do not believe that to be true at all. I know that there are good men and women in law enforcement, and that's why as a constituent, I am pleading with this committee to vote ought to pass on this amendment. It will enact professional accountability among law enforcement personnel. It will strengthen community trust with law enforcement, and it will allow the great men and women in law enforcement to hold their co-workers accountable without fear of repercussions for stepping up for what's right. It's for these reasons and more that I urge this committee to ought to pass on this amendment. Thank you.
Thank you. Are there questions? Seeing none, thank you for your testimony.
Okay, Madam Chair, we actually have Trixie Lefrave back, so hopefully she can connect.
Hi, this is Trixie. Can you hear me?
Yes.
Yes, hi. Thank you very much, Madam Chair and the members of the committee. I do apologize. I had to step out to respond to a bail call. I am a bail commissioner. I live in Londonderry. I'm speaking with regard to the amendment, which is contained in paragraph 11, Roman numeral 1, which you'll find on line 25 of page 73. I mean, excuse me, 7. Goodness, don't want to build that long. The language that's presented in that particular paragraph states that the court shall, to the extent of available funding, utilize all possible means to pay the bail commissioner fee. This is no assurance that our fees will be paid. The language places the funding for this inside the court's annual budget, but still does not appear to provide any avenue of enforcement to we the bail commissioners. If a bail commissioner is not paid at the time of their service, we have no enforcement or collection proceedings available to us. If this bill is passed and payment of the uncollected fees becomes the responsibility of the court in their budget, I would like to ask that additional language be added. I ask that the language be added so that the bail commissioners be paid monthly so that we can anticipate the payment and track the success of this new legislation should it pass. The present experience is that if the circuit courts have collected any bail commissioner's fee, we receive a check. There's no monthly or quarterly time frame. A directive in place for payment to these court-appointed contractors is a good business practice for both the payer and the payee. I have provided ideas over the course of my appearances during 2019 and 2020 here at the State House to aid the state in the reimbursement from the defendants for that $40 fee. In these ideas are actual devices of enforcement that can be used by the courts and the state to ensure that the fees, which we are entitled to by statute, are actually collectible. Implementing these concepts will minimize the budgetary expenses of the court by way of reimbursement. They are a mandate that each court be a point of collection and disperse the funds on a monthly basis. At this point, it's merely a courtesy to the bail commissioners that the courts collect on our behalf. Additionally, if the defendant makes application for a court-appointed attorney and is determined to be eligible, and their bail commissioner fee has not been paid, which is noted on the bail order form, that the BC fee come from this fund, and or send notification from the Director of Motor Vehicles for the unpaid fee to the defendant, and if the fee continues to remain unpaid, a suspension of driving privileges until the fee is paid. Include the payment of the bail commissioner into the collection process for the Office of Cost Containment if the non-payment still exists at the end of the case. The bail commissioner community is hopeful that there is a resolution to this growing problem and that our concerns are heard by the legislature. The passage of this is a step in the direction of making it right, but there is still a concern that the latitude of the language, and I'm emphasizing again, to the extent of available funding, leaves a gaping hole that may have us back here before the legislators to remedy in the future. And I thank you for allowing me to submit this.
Thank you for your testimony. Are there questions? Senator LeVake.
Good
Thank you,
afternoon, Senator.
Yes, good afternoon, Ms. LaFave, and thank you, Madam Chair. Ms. LaFave, can you tell us what percentage of the time do you not get paid for the work that you do?
We are at about 25 to 30% of our calls. Some of the bail commissioners are reporting a far higher number than that, and others have more success because they do have the support of their police departments by putting little drop boxes out front that only bail commissioners can access so that the defendant has the opportunity to come back at a later time to deposit that money. And as you had requested, Senator LeVesque, during the time of the commission that you're working with, the bail reform, you had asked for some real data from bail commissioners. And I had started that process by reaching out to the bail commissioner community, and I've been gathering that information. But of course, with legislation not being in session because of the COVID, I've not been able to gather all of that, that real data up for you that I have been working on in February and March.
Well, thank you. We'll look forward to hearing it. Could I have a follow-up?
Yes.
Ms. LaFave, you said 25% of the bails that you do are unpaid. Can you give us a dollar amount approximately?
Well, I know that from 2014 to 2017, I'm owed about $7,000. I had also at one point submitted some testimony, and I'm not sure which of the two, between bail reform or the Senate Bill 722 from last year, or that's presently sitting up at the State House, between 3 bail commissioners, 2 out of Manchester, and then myself, we had pulled our numbers together, and we were up to about $17,000 of unpaid between 3 bail commissioners.
Okay, thank you.
Yep,
Thank you
you're
for your
welcome.
work also.
Thank you. You're welcome.
No further questions? I do not see any. So we can go on.
Super. Next is Rory McDonald.
Hey, can you guys hear me all right?
Yeah.
Hi, I just wanted to speak on supporting passing some of the amendments in here, especially pertaining to language with officers if they see something that might not be legal, that they speak up. I moved up to New Hampshire from New York, and I'm Caucasian, I'm a woman, and as a 17 or 18-year-old woman, I was pulled over with 2 of my friends that were both people of color on a false suspicion of a drug deal. Based on the people that I picked up, because I picked them up at a bus stop, and it seemed strange to see a white woman picking up 2 black men. So I got pulled over 2 streets later. They illegally searched my car and falsely arrested a friend of mine on a warrant that didn't exist because they were worried there was something there. I then allowed them to search the vehicle. They found nothing. They let me go even though I was the owner of the vehicle and I was handing out job resumes. I hadn't seen my friends in 2 years and I wanted to catch up while I was looking for a summer job. I've seen personally so much racism in the police around there. I used to serve them daily their food, and I would hear the way they talked about people. It needs to be really seriously looked at because this was happening to minors. I was 17 at the time. My friends were as well. These were not grown men. They were not scary looking. And there is a definite injustice at the way that people are profiled in this area. There is such a lack of diversity up here that people instantly assume something based on what you look like, and it's not okay. It needs to really be looked at with the police around here. Please consider that. Thank you for hearing me.
Thank you. Any questions? Did not see any. Thank you.
Next, we have Aphrodite Michael Petroulis.
Hey again, everybody. I also would just like to make the point, it's been made a couple of times, and I thought it was really cool about the citizens being mandated to report certain types of misconduct and abuse amongst themselves. I've noticed there's a huge divide between the law enforcement and the people, which breaks my heart because I also have, I was in New York, like Miss McDonald, and came back. So we do possibly have a different view of diversity and maybe a little more of a comfort with certain things. But I will say that after coming back from a lot of bad things that had happened to me, I had officers literally just swoop up my spirit and make me feel okay and safe again. And I've also had situations happen where I was calling for help. My apartment got broken into after having been, raped and had to run away from my abuser from New York. So I'm in my little apartment in New York, and I smelled a really strong smell of some certain drug in my hallway, which bugged me out because I was a clean bean at the time. So I called the police because there was some paraphernalia left in my locked apartment. And when I had spoken to said officer, he then turned it on me, asked if it was possibly mine and etc. And it broke my heart to have, such good experiences and bad experiences. And I know it doesn't have so much to do with the exact bill and etc. that we're talking about now, but I feel like if we could bridge the gap to make everyone accountable, I think it would really take away the fear factor of police and citizens and people, because I'm a woman of peace and unity and respect. And honestly, sitting here and listening to all of you talk about these finite little details, this is my first thing to have anything to do with any governmental anything. I've seen the people cry out, and I got sick of being someone who was upset and didn't say anything and not having an outlet and not taking the responsibility either. So thank you for your patience. And thank you for being so kind to listen to some of this, even though it might be a little rambly. It's an attempt for the people to bridge the gap to the government. And maybe if we all do this more, we can really get somewhere. It's not about right and wrong and holding people up against the wall for things they have done or haven't done. It's about all kind of coming together and making a new vision. And just thank you guys. I have so much respect for you because this takes a lot of dedication and patience, open-mindedness and intelligence, and respect all day long. And thank you just for listening. Thank you.
And does anyone have questions?
No.
I don't think so, but thank you for your testimony.
Okay, next we have signed up to speak is Catherine Cooper. However, she is not on our attendee list at this time. So if she's calling in, please feel free to dial *9 and that'll virtually raise your hand. And in the meantime, we have Robert Page to speak.
Can everybody hear me?
Yes.
Great. Senator Hennessy and members of the Senate Judiciary Committee, thank you for allowing me to speak today. My name is Rob Page, and I am a lieutenant with the Nashville Police Department, where I've been a police officer for 20 years. I'm here to speak to Amendment 1455S, which I believe is page 10, section 21, entitled the Psychological Stability Screening. I'm speaking on behalf of the Nashville Police Department and the New Hampshire Association of Chiefs of Police in opposition to the funding mechanism of the Psychological Screening Fund. I am currently the Divisional Supervisor for Nashville's Drug Unit, and I oversee all felony-level drug investigations. I can testify that it takes thousands of dollars to run a robust drug unit like the one in Nashua. All of our operations in the drug unit are funded with money from our drug forfeiture fund. In fiscal year 2019, it cost approximately $85,000 to run operations in our drug unit. And we also spent an additional $20,000 to support our community-based programs such as Bridges, the Child Advocacy Center, and the Youth Council. All of that money was taken from our drug forfeiture fund. And conversely, that year, we only took in $81,000 to our drug forfeiture fund. State drug forfeiture represents approximately 25% of our drug forfeiture fund. So taking an additional $100,000 from the state drug forfeiture fund could have a large impact on our ability to safely run our drug unit here in Nashua. Nashua PD is one of the major contributors to the state drug forfeiture fund, and we currently pay for all our own psychological stability screening tests that we submit every potential officer to here in Nashua. To additionally take more money from the funds that we receive that are based on the seizures that we make, it is our stance that it's unreasonable and it could put our drug unit in a precarious position. To supplement these funds that are lost each year, we'll have to cut funding to the community-based programs, and we lose our ability to support the great organizations such as Bridges, the Child Advocacy Center, and the Youth Council. These organizations affect victims of domestic violence, sexual abuse, crimes against children, and the youth growing up in our community. Additionally, if these funds are lost each year, we may have to look to the city budget to try to supplement those losses. And unfortunately, now you're shifting that financial burden from the drug dealers, where the money comes from for drug forfeiture, to the taxpayers. Ultimately, losing money in drug forfeiture funds can lead to losing our ability to safely operate our drug unit. This puts the national community in a dangerous position at a time when there is an opioid epidemic and overdoses are still high. Thank you for your consideration.
Thank you. Are there questions? Senator French.
Thank you, Madam Chair, and thanks for your testimony today. So we had a similar bill to this before, and I think your department testified. I asked that and I couldn't remember the answer. What is the budget of your department?
I don't know our actual city budget, but what I can tell you to identify kind of how we run our drug unit is the officers' salaries are paid from the city budget. However, all operational expenses, and now you're talking about drug buy money, you're talking about offsites, cars, phones, surveillance equipment.
Yeah, the entire budget was 20 million or thereabouts, was it?
I'm not sure, sir. I don't have that information, but I could get it if you needed it.
Yeah, if you could.
Sure.
Hey, thank you.
Are there other questions? I have just a quick one, and that is, thank you for being here. And I just wanted to ask if you were aware that this funding is for until the next budget is published, in which then it will be part of the budget.
Yes, I learned that today. Thank you.
Okay, thank you. Seeing no other questions, we can go to the next person.
Okay, next we have Scott Naismith.
Good afternoon. Can you all hear me?
Yes.
Perfect. Thank you, Madam Chair and members of this committee. My name is Scott Naismith. I am a police officer in Salem, and I currently serve as the president of the New Hampshire Police Association. Before I speak on the amendment dealing with the reporting process of law enforcement misconduct, I would like to say a few words about the events that took place in Minneapolis a few weeks ago. The death of George Floyd, excuse me, has caused anger, outrage, and frustration with all law enforcement in New Hampshire. This incident has heightened the fear and mistrust that some citizens of our state may have for law enforcement. I am here today to state that the New Hampshire Police Association wants to work with you to make sure that an incident like this never happens in our state. Today, I'm here to convey that law enforcement realizes that there is a need for change. Representatives of the state's major law enforcement groups, like the New Hampshire Police Association, the New Hampshire Troopers Association, and the New Hampshire Chiefs of Police Association, came together recently to review this amendment and to make it into a workable process for the reporting of law enforcement misconduct. We do support language to require misconduct reporting. In closing, I would ask that you allow us to work with this group to bring some changes forward to this amendment so that we can all work together on this, on the issues raised in this amendment. Thank you.
Thank you. Are there questions? Senator LeVake.
Thank you, Madam Chair, and thank you. Is it Chief Naismith?
It's Officer Naismith.
Officer Naismith. Thank you very much for your words. I truly appreciate it. You were saying that we would work together to make an amendment. Are there some suggested amendments that you have?
Some things that we came up with would be obviously the use of a chokehold in law enforcement. That is that is a technique that is not taught by New Hampshire police standards and training, and we would support a proposed ban on this chokehold. I know there's been a lot of talk about that in the country. We would just ask that the circumstances which are laid out in the New Hampshire Criminal Code under section 625 2A be included, which state a law enforcement officer is justified in using deadly force only when he reasonably believes such force is necessary to defend himself or a third person from what he reasonably believes is the use of deadly force. Other than that, we have no issue with the banning the use of chokeholds. Some other changes that we had discussed were getting rid of the 7-day reporting policy and making that immediate or as soon as is practicable after observing such misconduct for the officer.
I'd just like to say that you're saying many of the things that we actually will be having and you'll be hearing. So keep listening, because many of those are already being amended.
Great, thank you.
Thank you.
No more questions that I see.
Next, we have Michael Skibby. You should be all set.
Good afternoon. My name is Michael Skibby. I'm the Policy Director of the Disability Rights Center, and I'm testifying in favor of Section 2 of the amendment, which is the same language as was contained in Senate Bill 755. This bill came about because the Attorney General has taken a new position on the interpretation of RSA 491:8, and that has thrown into question the validity of many settlement agreements between the state and its citizens, which were negotiated in good faith and upon which they rely. We believe this provision is about the simple principle that when the state makes a promise as part of its settlement of a lawsuit, it should not be permitted to renege on that promise. The bill would not require the state to settle lawsuits in any particular way, or indeed to ever settle a lawsuit. But when it does settle a lawsuit, the bill would require the state to be bound by the promises it makes. This issue came before you for public hearing on the underlying bill. And during that testimony, you heard from several organizations and attorneys that regularly help people who have been harmed by actions of the state. Those cases that they described involved the developmental and mental health services where federal or state law was not being followed, civil rights actions, and employment actions. As we discussed at that prior hearing, confidence in the enforceability of settlements of litigation is fundamental. The civil justice system in our state would not function with existing resources if that confidence was missing. Both citizens and the state would be forced to fight cases out in court much more frequently, even when no one disagrees that the plaintiff is entitled to some relief. When those cases are civil rights cases, the state will pay the plaintiff's attorney's fees in many circumstances. It's much more expensive for the state and for the citizens that have been harmed by the actions of the state, not to mention the resources of the court system. At a prior hearing, questions were raised about how this bill would have possibly have some negative fiscal consequences to the state, but precisely the opposite is true. If the Attorney General's interpretation of the existing statutory language prevails and the statute is not modified, the resulting reduction of settlement agreements will put the state more at the mercy of unpredictable and expensive litigation and judgments resulting from that litigation, not less. One final point, the state is in complete control of its financial exposure simply by drafting good contracts and drafting good settlement agreements. You can control your liability by only promising what you can actually perform, and the state can also control remedies in the agreements themselves with explicit limitations in the contract language. I'd be happy to answer any questions. Thank you for your attention.
Thank you for being here. Are there questions for Mr. Skibby? I see none. Thank you very much.
Thank you.
We have John Skippa.
Welcome again.
Thank you very much. And thank you, members of the committee, for giving me this opportunity to speak. Generally speaking, I've seen a number of iterations of the amendments that have come through. And so I apologize if I speak generally to them. Overall, I could not agree more with Representative Cushing's position on the vetting of candidates to be police officers in the state of New Hampshire. That psychological screening process is an absolute necessity as part of the overall screening process on a candidate. To that end, I share the same concerns that Senator Levesque and Carson share with regard to diverting funds from an enforcement fund, so to speak, taking away those funds to be able to pay for this psychological testing. And I would ask that the authors of the bill consider looking back to the penalty assessment fund to draw those funds from. To the Madam Chair's position, I do understand that this is just for the rest of this biennium, and then there would be a new funding source found, but I would ask that the committee consider that. With regard to the reporting of misconduct, absolutely support this particular amendment as it is put forth to my understanding. There's one small bit of concern I have with, I believe it is paragraph 4, and that refers to the fact that police standards and training might have to release information. And my only concern would be that that release of information might be too early in a process where a police officer is being charged criminally. And I would not want to in any way cause a question of due process that would allow the officer or the criminal to have a defense without really looking at the facts of the case. So that would be the only concern there. And then I'd like to reiterate to everybody that here at Police Standards and Training, we do not teach in any way a stranglehold, a chokehold, nor do we advocate any pressure or force being delivered to the back of somebody's head, their neck, or their spine. That is not supported or taught here. The only other piece to this would be
to interrupt Senator Hennessy. That's been 3 minutes.
Thank you. Could you please finish your sentence and then we will move on?
The only bit would be the housekeeping. There was mention specific to the chokehold. That might just be better to place right under 627.5 2A. It would just make it less cumbersome as opposed to putting that in RSA 631:11. Just build all that language right into 627.5.
Thank you. Thank you very much. I'm sorry that your time is up. And are there questions? Senator LeBake.
Thank you, Madam Chair, and thank you, Officer Skipper. Question about the Police Standards Training Council. Do you require all trainees to have psychological testing?
Yes, madam. That is both an administrative rule and is written into RSA 106. And that is actually a responsibility of the hiring authority to conduct that testing.
Follow up?
Follow up.
Thank you. And can you tell us why the payment of this testing is not covered by towns? Traditionally it is, but apparently not always. So why isn't it covered?
There is a variety of reasons, and I'll speak from my experience as a chief of a police department here in New Hampshire. Some of the smaller agencies may not anticipate having to fill an open position, and they may not have budgeted that $500. And they may have an opening that comes very quickly. The police officer transfers to another department, and now that hiring authority that needs to hire the new officer did not anticipate the financial impact of that particular test. And that's why they don't conduct that psychological test. In other cases, I have heard the argument that it is an unfunded mandate that's being handed down to the municipality. It is an absolute necessity to have this vetting process in place, and it is the responsibility of the hiring authority. And the fact that the state recognizes it as being so important that they're seeking a funding source, I can't thank you enough for helping us try to get this thing done.
Thank you.
You're welcome, ma'am.
Any further questions? Seeing none. I can't see Senator French or Senator Chanley, so I don't know. I don't think they have questions. Oh, you do? Senator Chanley does? Oh, there she is. I just saw her, and I just saw Senator French. The magic of Zoom.
I think the hand was a no.
Questions. Sorry. Thank you very much, Mr. Skipper, and we will go on to the next one.
Okay, the next we have signed up to speak is Claire Dennis. However, I do not see them under the attendees list. So if they're here, please feel free to virtually raise your hand or dial *9. In the meantime, the next person we have on our list to speak is Charles Douglas. Again, I no longer see them in the attendees list. So if you are here, please feel free to virtually raise your hand. Jared Bedrick is the following speaker. So I'll allow them to speak and then look for those hands if they end up being raised.
Thank you.
Thank you. And I'm sort of taking the place of Chuck Douglas. So I had swapped out, so he won't be appearing, but I'm Jared Bedrick. I'm an attorney at Douglas, Leonard and Garvey. I practice with Chuck Douglas, and thank you, Madam Chair, for having me and allowing me to speak on this. We are here in support of the amendments, specifically to discuss the one piece, I believe it was from Senate Bill 705, Section 2, which adds language to allow a citizen to seek specific performance or other equitable remedies against the state. And the reason why that's so important to us is because we do a fair bit of litigation against the state, which thankfully often results in some sort of settlement agreement. And the settlement agreement can contain a number of different ways of resolving the case, creative or otherwise. Usually there's a monetary component, but in cases like ones that we've recently had, there is either reinstatement to some position in government, reinstatement to some committee, or in other cases in the past, you have negotiations where the state will agree to stop a certain practice. You can imagine a situation where the state, in order to resolve a particular case, would agree, say, to stop teaching or promoting chokeholds or something like that, right? The problem is that you get into these, there is a specific clause in just about every one of these settlement agreements that says either party is allowed to sue the other for breaching, for violating the terms of the contract. However, it's kind of a false situation here, because even if the contract says that, the citizen, not the state, just the citizen, cannot ask for a certain remedy in the court. So let's say you get the agreement that the state is going to stop using chokeholds, and then you turn around and 10 days later you see the state teaching and promoting chokeholds. Not saying that they would, not our state apparently, thankfully. But if that were the case, they would be in breach of the settlement agreement, and you would have no way of going to court, because the only remedy for that would be to ask the court to specifically perform that part of the contract. And since you can't do that right now, we're asking for a new provision in the law that says that you can't.
Senator Hennessy, that's been 3 minutes.
Thank you. And thank you for your testimony. If you were in the middle of it sounded like you had pretty much finished a sentence, but if you were in the middle of one, feel free to finish it.
No, I'm all set. Thank you very much. I appreciate your time, Senator.
Thank you. And are there questions for Mr. Bedrick? I don't see any, so thank you very much for your time.
So, Madam Chair, that is all I had for folks signed up to speak. However, we do have 2 hands raised. John Krupski.
Okay.
Hi, can you hear me?
Yes.
Hi, this is Attorney Mark Bodwin. I'm going to be speaking on behalf of John Krupski, who's we're in the office here together. We represent the New Hampshire Troopers Association, and specifically, I'm also the executive director of the New Hampshire Troopers Association. So I'm speaking on their behalf. As a background, I'm a retired trooper as well. So first, let me say that what happened to George Floyd several weeks ago was just wrong. So I'm not here to discuss that any further than to say that the Troopers Association condemns that action. However, in reference to the mandatory reporting amendment, I'm happy to say that we have worked with several of the members of the Senate here to come up with some amendment that we feel is workable and that is important here for New Hampshire. And we support the amendment for mandatory reporting, and we also support the banning of chokeholds as well. Those aren't, as you've heard before, those aren't taught in New Hampshire, and they're not taught at the state police either. So we also agree with John Skipper when he was said bringing that ban of the chokeholds into RSA 627(5).
Thank you very much.
Thank you.
Are there questions? I do not see any, but thank you for being here to testify and for your help.
Thank you very much.
Okay, and before we lose you, sir, can you just confirm your name for the record? I know we see John Krupski, but.
Yep, sure. It's Mark, M-A-R-C, Bodwin, B-E-A-U-D-O-I-N, and I'm the executive director of the New Hampshire Troopers Association.
Super. Thank you.
Thank you.
All right, Madam Chair. So we have, again, no one else left to sign up to speak. We have 2 hands raised. One is Christopher Marino, who has not previously testified, and then we have Daniel May, who has. So I can allow Christopher Marino to speak. Yeah.
Hi, can you all hear me?
Yes.
All right, so I did sign up to speak on Amendment 1380, I believe, but it looks like we're on 1455. And I guess just before I get into my position, I just wanted to point out that on Amendment 1455, and Madam Hennessy, I don't know if you mentioned this, but one of the bills that seems to have been rolled in there seems to be a shuffling of the entire bail statute. It seems to be, I'm not sure if that's one of the bills that you mentioned, but I wanted to point that out to not only to the committee members, but any other bail commissioners who might be listening in. It looks like this amendment that we're talking about and hearing about right now would completely shuffle how we do our jobs. So that's the first thing I wanted to bring up. The second thing I wanted to bring up is there was another bail commissioner here. She spoke, she brought up great ideas on how the payment to bail commissioners could be done. I think, like she brought up, I think how the bill's worded to the extent of available funding, that basically leaves the courts, not that they would, but that just leaves the courts in a position where they have all these other things they have to pay for. It looks like they would need to pay for these identification cards. And essentially halfway through a fiscal year, the courts could run out of money from whatever source and say, we can't pay you guys anymore. Or they end up between a budgetary rock and a budgetary hard place. So I wanted to bring that up as well. Senator LeVake, it looks like you were asking for some bail commissioner data. I sent you my data that I've been maintaining since I was appointed last May. You're welcome. And one last thing I wanted to say too is this bill seems to be setting up a committee for remote access to bail commissioner services. I can tell you on behalf of myself, and I'm sure plenty other bail commissioners, the courts afforded us that opportunity to go ahead and begin to do those electronically. So I'm not sure if it's, I'm not going to call it a waste, but I'm not sure if it's worth the legislators' time unless they want to set up a new system. But I think all that needs to be done in that regard is to just have the courts continue to allow commissioners to do it electronically. I typically do it by phone. Sometimes I do it by Zoom. So that's all I had to say, and I can take any questions you may have.
Madam Chair, Senator LeVake's virtual hand is raised.
Excellent, thank you. Go ahead.
I'd like to wait till Christopher is done, if there's any questions for Christopher.
So I'm all done speaking if that's what you're saying.
Are there questions for Christopher Marino? Seeing none. Thank you, Christopher. And now would you like to say something, Senator?
Yes, thank you, Madam Chair. I wanted to speak on Senate Bill 551 for the pretrial hearings and talk to the work that the Bail Commission has been doing. Senate Bill 551 was heard March 10th. It was not exact, but it was heard. And the bill that we brought forth was a culmination of all of the members of the commission. We had law enforcement, county attorneys, public defenders, the ACLU, the Attorney General's office, legislators, and judges. And we actually got everyone, and we also had corrections. We managed to get everybody to agree on an amendment for bail reform, which is now in Senate Bill 551. One of the things that we added was a bail commissioner, and I will thank Trixie LaFave for attending all of the meetings, so she was able to give feedback. Now we will have a bail commissioner on the commission. But it also refined the statute to clarify PR bail. It would allow conditions rather than cash bail. And it also recognized the Hill decision, which also allows cash bail. And that was a judicial decision that was made recently. It still gives judges the ability to hear bail hearings and understand the circumstances and then make recommendations. We did make some slight changes to the bill between the time we heard it and today, and they're very small changes. On page 4, lines 33, we removed after a hearing, And on line 35, we added, the defendant shall be afforded the opportunity to be heard. This was a request of Judge Neto and also echoed by Chief Toussaint. So we've been working really hard to make this something that we can all agree on and that is workable. And I also want to say that we realize that there are underlying issues and factors for some people that continue to reoffend. And it could be substance misuse disorder, could be mental health or homelessness. We also realize that there's got to be resources for these people so that we can assist them further. So thank you, Madam Chair. I just wanted to shed some light on Senate Bill 551.
Thank you. I appreciate that. I think it in fact answers some of the questions that were being asked. So thank you. So seeing no other questions or comments, I think do we have others who would like to speak?
Yes, Senator. So we have Chief, let me find him here, I apologize. Chief Charlie Dennis.
Excellent. He's from my area. Welcome. Are you there?
They appear to be unmuted on my end.
It does look as if you're unmuted.
Can you hear me?
Yes, well, there's an echo.
Hear me?
There you go. Welcome.
Thank you, Madam Chair Hennessy and members of the committee. I'm just confirming again, you can hear me.
Yes.
All right, thank you. A lot of technical difficulties here. My name is Charlie Dennis. I'm the police chief in Hanover, New Hampshire. I'm here today representing the New Hampshire Association of Chiefs of Police in response to the amendment, Section 15, titled Reports of Misconduct by Law Enforcement Officers. Here in New Hampshire, we have always had a system in place for misconduct. It is expected that any officer who sees misconduct will report it immediately in order to ensure that we safeguard the tenets of our code of ethics and responsibilities as guardians of our communities. Our goal is and will always be to build and strengthen relationships with the citizens we serve. The bedrock of these relationships will always be mutual respect, accountability, and trust. We look forward to working with the committee on a bill that would add more specificity to that and further ensure that law enforcement agencies are handling police misconduct uniformly across our great state. Moreover, we support clear and concise language relative to the definition of misconduct while ensuring a standardized process for all to follow. We in New Hampshire law enforcement pride ourselves on upholding our very sacred oath through transparency and accountability. We feel strongly that we have a good system of policing in this state, and it is important for all to know that we are committed to improving what we do and how we do it for the citizens we serve. We want to ensure that we are demonstrating respect for all through the delivery of our services while building trust and legitimacy in our agencies throughout New Hampshire. We have seen several amendments in the last 24 hours and continue to see changes within the last hour or so. And honestly, I'm not sure where we are now with this section. What I can say is that the chiefs support the following. 1, adding excessive and illegal use of force to the definition of misconduct as defined by the New Hampshire Criminal Code. 2, we support adding that any law enforcement officer who observes misconduct by another law enforcement officer is to notify the chief law enforcement officer in writing immediately or as soon as practical. And 3, we support that no discriminatory, disciplinary, or retaliatory action shall be taken against any officer for any information given or disclosed by him or her in good faith in the course of making a report of misconduct under paragraph 2. In closing, I've been saddened by some of the personal stories that I've heard today. But hearing some of those same stories, I'm also hopeful by some of the same things those people said of the positive interaction they have had with law enforcement, knowing that the majority of law enforcement are good people and former human beings too in our communities. In closing, again, we desire further conversations around this important issue and other issues surrounding police reforms, and our association would welcome and value the opportunity to work collaboratively with this committee. Thank you.
Thank you very much. Are there any questions? Nope, I don't see any. So thank you for your testimony, Chief Dennis.
Thank you.
Okay, Madam Chair. So again, that's all we had signed up to speak. Daniel May, who had previously testified, had his hand raised. However, I no longer see his hand raised. So I have no one else at this time.
Okay, I will then close the hearing on Amendment 1455. And I would like to just tell you what my plan is, because I know we're all getting antsy. I would like to, with your indulgence, go into executive session to do the sexual assault omnibus before we have a recess, because I know there are a lot of people who've been waiting a very long time to get to that point. But I'm also interested if somebody thinks that that is too long to wait for a recess. That's okay? Okay, great. So I will entertain.
That we go into executive session.
Thank you. I've heard a motion to go to executive session made by Senator Chanley, seconded by Senator LeVake. And I will take a roll call. So Senator Chanley.
Yes.
Senator LeVake.
Yes.
Senator Carson.
Yes.
Senator French. Oh, Senator French.
Muted.
Are you okay with going into exec? You have to say yes.
Yes.
I didn't mean to say you had to say yes. Anyway, thank you. So we are in executive session.
Senator, sorry, Senator Hennessy, you have to vote too.
Oh,
Sorry.
yes, I'm sorry. I keep forgetting that. Yes, I also say yes. I got, yeah, okay. So we are in executive session and I will entertain a motion on HB 705.
I move to pass on HB 705.
Thank you, Senator LeVake, and seconded by Senator Chanley. The motion is ought to pass on House Bill 705. And the next thing we need to do is to move Amendment 1305.
Don't we need to take a vote?
No, we were just moving
Okay.
at that point. So now we're taking.
In the amendment.
Okay. No, I was talking about the bill itself. We just had a different process that was outlined to us yesterday than what we're doing today. It's just can be a little confusing sometimes, so. I will.
Going by the expert people who are giving me advice, not something I've been told. Is that correct, Jenny?
Yes.
Okay. So we have a motion, I believe, and a second on, oh, do we have a motion? No, on Amendment 1305.
I'll move 1305.
Was that Senator Chanley?
Yes.
Yes, okay. So Senator Chanley moves to pass on Amendment 1305. Is there a second?
I'll second that.
Senated by Senator LeVake. Okay, so we then are open for discussion before we vote.
I have a problem voting for this with over-the-counter rape test kits at issue here. I wish we could make that a study committee. And rest. And I don't like the elimination of statute of limitations, but rest is good legislation.
So I understand that we did hear from a lot of people about the rape kits. And I have to say that I will respectfully agree with you on that, Senator
Sure.
French, as the people I've talked to have certainly been a lot of the people that I've talked to who do these kinds of exams, as well as the people who, as well as the
You got
people.
a cat at the State House?
That's my cat.
Oh,
He's
that's your cat,
meowing.
Sharon. Okay.
Okay, that's okay.
I can't mute, and he's standing here crying.
That's okay. That's okay. He wants to be part of it.
Yeah.
It is my great concern that from everything I've heard, that if we allow people to use something that is labeled as a rape kit, that it sets them up for having inadmissible data or whatever. I don't know the legal language. Anyway, so, but I do know also that you are correct that it's a kit that has swabs and things. People can very definitely collect their own data or their own, what's the word?
Specimens.
Evidence, nonetheless. So to have a $30 kit that has things in it that one could learn to do themselves is up to any individual. In the meantime, I believe that all the other things that go with a rape assessment are extremely important to the well-being of the person. And it doesn't mean they have to report it to the police. That's my comeback. But is there any other? Yes, Senator Carson.
Thank you. I tend to agree with my colleague. I think we're taking away the rights of an individual to buy a product that they choose. And I think that perhaps a study committee might be a good way to look at this issue, because you can, I mean, we do sell over the counter other types of kits. You have pregnancy, you can have kits that look for blood and stool samples and things of that nature. But I think if it's with proper packaging to let people know that if they buy this, any specimens that they collect are not admissible in court. I hate to see us ban something that we've had so many people come and testify about that they would like to be able to have, because probably what's going to happen is people will go across the borders to get it, and we're really not doing anything except banning something here in New Hampshire. They'll get them anyway. They'll buy them over the internet. They'll go on Amazon Prime and buy them.
Go ahead.
Of banning a product here, let people have choice, but I think it needs better messaging, better packaging to let people know that whatever they collect is not admissible in court.
Well, we aren't sure of that either.
Yeah.
And with all due respect, the other kits that you've talked about are not being used in court hearings. You know, a pregnancy test.
I agree. I agree with you, Senator, on that. I just see that people are still going to get them. They're just going to buy them over the internet, or they'll go to Massachusetts, Vermont, or Maine and buy them. We're just saying you can't buy them here. That's all. And I just don't see the purpose of it.
Honestly, I have some very serious concerns about the companies that are doing this, and the motive is, you know, to be financially successful, which in fact they're selling something that you can buy over the counter yourself already, and you're paying quite a bit of money for it when you can get it for free by somebody who's actually qualified. So.
Okay, well, thank you very much. I think we're just going to have to agree to disagree on this. So.
Okay.
Madam Chair, are we just talking about the amendment now, or can we discuss the bill as well?
No, right now we're talking about the amendment, which includes the bill. The bill is in the amendment.
Okay. One of the questions I had about the bill was, and I'm getting back to the bill 705 itself, on page, let's see, it was the committee, there was some sort of committee that was set up, establishing a committee on the needs of victims of crime and enforcement of crime victims' rights established. There are 2 members of the Senate appointed by the Senate president. I didn't know if the committee members wanted to amend that. Usually we just have 1 senator as opposed to 2. So I didn't know if anybody had any objections to bringing that down to one senator, or there might be two senators that might want to serve on the committee? Just a question.
I don't have an answer to that. Were you trying to say something, Senator Chanley?
I am so sorry. I try to mute so you don't hear background noise. We generally do bring it down to one. I don't object to bringing it down to one, but other than that, I'm very good with everything as is. So if that was a committee change to the 1305, I don't object to that at all. But that's, either way, I'm fine.
And I would support that.
Okay, so that would be a committee amendment, or can we, yeah. Or we can just do that, can't we? Just as a word amendment? Yeah, okay. I think that's a good plan. That has been our way. Are there other comments?
It's good.
Okay. Okay, so what I'd like to do then, I guess, is go ahead and have a vote on the motion of to ought to pass on 13, is it 05?
1305 with the one small change.
With the small change. So we just need Senator Chanley and Senator LeVake to agree to amend their motion to be a committee amendment rather than the amendment itself.
Yes, I will.
No. Okay, so we vote on the committee amendment first with the change from 2 senators to 1 senator. Okay. Although I'm going to do a roll call, sorry. And I'll
I did the same thing yesterday, Senator Hennessy. So
have-
used to go, I want to call, all in favor, say aye, and
Yeah, right,
oh,
exactly.
no, I can't do that.
It's such an instinct. So I will start. Senator Chanley,
Yes.
Senator LeVake,
Yes.
Senator Carson,
Yes.
Senator French.
May I ask one question, please, in
Yes.
the middle of this? Are we voting on just that one change?
No,
Yeah.
we're voting on the amendment. Oh, we're voting on the
We're
one.
voting on the one change from 2 senators to 1 senator first.
Thank you. Yes.
Nope, sorry. We were voting on the committee amendments.
With the change.
Oh, with the change. Okay.
Then no.
Understand that, Senator Carson?
Yes.
Okay.
Then
And-
no.
Okay. So we have passed the ought to pass.
Senator Hennessy, I'm sorry, you have to vote still too.
Please with me.
I'm voting yes, Senator French. Thank you. And we have passed the amendment to 1305 with a roll call vote of 4-1.
And I will move.
I will designate myself to take that out unless there's any objection.
So we have a pending motion on the bill itself with Senator LeVake moving the bill and Senator Chanley
Oh,
second.
that's right. Oh, that's okay. Now I get it. Oh, okay. So now we have a pending motion on the bill itself, now that it has the amendment, which is we need a roll call for, and I will start with Senator Chanley.
Yes to
1305.
705 with the amended, as amended by 1305. Yes.
Okay, thank you. Senator LeVake.
Yes.
Senator Carson.
Yes.
Senator French.
No.
Thank you. Now we have passed.
No,
and
Madam
Hennessy said
Chair.
yes. I should go first so I don't forget. Yeah, yes. And so we have passed 4-0. The
No,
second
4-1.
13,
4-1.
I'm sorry, 4 to 1.
14 to 10.
Pride.
Okay.
And so as a result, we will now go in, we are going to, do I have a motion to go out of executive?
Wait, so Senator Hennessy, sorry, just to confirm, you're
moved.
taking that one out.
I'm taking that one out. Thank you.
Yeah. So moved. I move that we go
Out of
come out of executive session.
Thank you.
Second.
very much. Is there a second?
Yes, second.
Thank you. Not all those in favor. Those, we need to do a roll call vote on
Yes,
going
we
out of
do.
executive session.
Yes.
Stanley,
Yes.
Senator LeVake,
Yes.
Senator Carson,
Yes.
and Senator French.
No,
You don't want to go out of executive session?
4-1.
Okay, I will vote yes, and we are voting 4-1 not to go out of, that's because you already got your fresh air break. We will go into recess we will try to make it 5 minutes because then we'll come back to exec again. Sure, or should we say 10 minutes?
Okay, thank you.
So sorry, really quickly before everyone goes, we did receive a new amendment on 1645. Yeah, 45. It has been sent to the committee members and hopefully we're having a little bit more luck with our IT right now. So that should be up online any second now.
Excellent. Okay.
The number of the amendment is?
It is, I don't see it. Oh, is it 1489?
Yes, 1489.
1489.
Thank you.
Thank you very much. So we will go into recess and be back. Let's say 7 minutes. Thank you.
No, Cameron makes the best cookies. It's crazy. Yeah, so you got to get his recipe from him. Guy's amazing.
Senator French,
Oh, wait, I didn't mean to be off mute. Hold on.
I want to go through all of the Zoom meetings that we've done together and just see how many official records there are of you applauding my cookies.
Yeah.
Not enough, Cameron. Not enough. I'm a big fan of his shortbread.
There
I
are at
do.
least three
Stay
records.
away from his cookies.
Sarah French, what's your favorite Cameron Lapine cookie batch that you've
The
had?
shortbread.
Me too.
Cookies.
For sure. The best by far.
I turned down all the others.
Wow. I don't.
Oh, are they really good?
I mean, they're all very good. I mean, who's turning down, homemade cookies? Honestly.
Yeah, that's true.
Come on, Senator.
That's true. Well, yeah, I'm trying to watch my weight.
Yeah.
Critically important.
Well, you really know how to watch the time too, Senator, because,
Yeah, I smoked 3 cigarettes. It takes me
no, you were checking the weather, Senator.
it's
Checking
1.5 minutes per
weather.
cigarette and 30 seconds to run out and back. So
Really get them in one after the other.
chain smoke.
Cam, did you have enough time to brew another pot of tea?
I did not. I put my teacup in the dishwasher. That's what I did.
You put your kettle in the dishwasher?
No, the cup I was drinking out of.
Oh.
No, I don't put my electric kettle in the dishwasher.
Good.
Cameron, you're such a neat cleaning up. I just put mine on the stack of dirty dishes.
And just leave it there for weeks?
A couple weeks.
Okay.
Till I run out of mugs. Then I have Jane do them. Beautiful day out, huh?
I wouldn't know. I've been inside all day.
Oh, Senator
Oh,
French,
gorgeous.
this is your command, Cam.
Webster is a gorgeous place.
Well, I'll jump on the canoe.
That sounds nice.
Okay.
All right.
Sorry, I had to come back in because I foolishly left. I think I was ready to get in my car and drive away, but no, here we are.
All right, I'm here.
We're glad to have you here, Senator.
Why, thank you. That's very kind of you. Is everyone here? Not quite. I see a very nice picture of Senator LeVake, and I don't know, maybe Senator Carson's name is there. And there's my friend, Senator French.
Senator French, looks like you got a tan.
Very.
Apple orchard tan.
Orchard tan.
There you go.
Jealous.
Mm-hmm.
Don't be, I got sunstroke 3 days in a row.
Oh, no. That's awful.
Hot work.
Do we have Senator Carson with us?
She's there. Here,
I
She's
see
on,
her name.
but she may not be.
you can't see her picture?
No,
She's waving to you.
you're lying to me. This is the guy who can sell anything.
I'll send her a text message.
Although I was born yesterday, I still am
That
on-
night, not last night, right?
Yeah.
Oh,
I mean, I've been around for at least 20 years. So
yeah. 21.
21, at least 21.
What are we taking up next?
We are going to where we are is that we have already had a motion on 1645 about to pass. Now we're going to we've had a, is that correct?
No, we don't, we haven't had a
We
motion.
have no motions on this. We're gonna
Pass-
go into we need a motion to go into executive session next, and then we'll go in on the criminal justice bills.
So moved.
Is Senator Carson here?
Yep, she's
Oh,
there.
hi.
Oh, she's there. Great.
Hi. Seconded, unless somebody else did.
I didn't see who moved it, but maybe Jenny did. So who moved the going into executive session? Thank you. Oh, Senator French. Thank you, sir. And then it was seconded, I believe, by Senator LeVake.
Yes.
So I'm going to do a roll call to go into executive session, and Senator Chanley,
Yes.
Senator LeVake,
Yes.
Senator Carson. I think you're on mute, but that's, but I saw you say
I
yes.
saw
and
her
Senator
lips
French.
move.
Yes, I saw that.
Yes.
Senator Carson.
And
you're-
I will also vote in
Yes.
favor of going into executive session. And I just heard Senator Carson say yes.
Yes.
So we are in executive session, and I would like to entertain a motion.
I move ought to pass on HB 1645.
Second.
It is moved and seconded. And again, what we will do now is move, now it is Amendment 1489, which you all should have been able to see during our recess.
I'll move that.
Thank you. Seconded by
I will second.
Senator LeVake. You're our movers and shakers today. Okay, so everybody's on the same page here. We've moved House Bill, why did I go there? 1645, and we are now going to have a roll call vote on Amendment 1489.
Unless you want any discussion.
Unless
speak to
somebody
it?
would like to discuss.
Yeah. Madam Chair?
Yes, Senator LeVake.
Well, I just want to thank everyone for putting this together. I think this is very important and also very timely. We heard a lot of really good testimony from our law enforcement, and I want to thank them, as we all thank them for their words of commitment to our communities. And it was very heartfelt, and we know that there's a lot of good people out there, and actually they helped us work on some of these amendments. And it shows that when you work together, you can really get a good product that works for everyone. So I want to say thank you very much. And I want to thank Madam Chair for managing this process. It's kind of crazy. Thank you very much.
Yeah, I also would like to thank the police for their really good cooperation. And I will by name mention Chief Dennis, the chief in my town, but all the others as well who have put in a lot of energy and effort. Is there any other discussion before we do the roll call vote? Okay, so I will call the roll on the motion of ought to pass on Amendment 1489. Senator Chanley.
Yes.
Senator LeVake.
Yes.
Senator Carson.
Yes.
Senator French.
Yes.
And I will also vote yes. So we have a vote of 5-0 on ought to pass. And I wonder if maybe with all your work on bail reform, Senator LeVake, if you'd like to take this out.
Sorry, Senator. We have to take a roll
done yet.
on the final, on the bill itself.
Oh,
As amended.
I always jump to the end. I'm so ready to be jumping.
Ready to go.
A roll call vote on ought to pass, and it's right in my notes, on amendment, on the amendment on, with amendment on 1645. Senator Chanley, or unless there's discussion. No. Senator Chanley.
Yes.
Senator LeVake.
Yes.
Senator Carson.
Yes.
Senator French.
Yes.
And I also vote yes. Now I'd like to ask, right, if Senator LeVake would like to take the bill out.
I would be quite honored, Madam Chair. Thank you.
Thank you. And now I think we are actually going to come out of exec before we go to the housing. No, because we already heard it.
Yeah.
Unless there's a desire of the committee, I don't think so. The committee's had the amendment for a significant amount of time, considering what significant amount of time is now.
What time it is now, yes. So we are going to finish the work we started on the housing omnibus with House Bill 1247. And I believe you've all had a chance to see the amendment. Is that correct?
Is that 1433S?
It is.
Okay.
Yes, I have seen it. Thank you.
Wait, is it 1433S? Yes, it is.
Yes.
Okay, so we need a motion on House Bill 1247 first.
I'll move on to pass.
Thank you. And just for variety, I will second. So we have a motion of ought to pass on 1247. And the next thing we need is to have a motion on the amendment 1433S.
I will move on to pass.
Thank you, Senator LeVake.
I'll second that.
Thank you, Senator Chanley. And I would just like to make a quick. Oh, no, I don't need to do that. Well, I just wanted to say that again, we had a lot of people involved in trying to make this into a good amendment that would address what a lot of the concerns were that we heard in committee. So is there any other discussion around the amendment 1433S? Senator Chanley?
Yeah, and I will say, this was a tough one for me. I did not, I understand the good intentions in every way around trying to make sure that folks who are suffering with difficulties paying their rent or their mortgage, and there were two different parts of this bill due to COVID-19, we need to be sensitive to folks and we need to address those concerns. The way the bill and amendment originally came to us, I really felt not comfortable with. I appreciate everyone who worked on the amendment to sort of take a little bit of a step backwards, not backwards, but back from where the bill was. you know, we may be in that position where no one is thrilled, and I don't know if that's a good thing or a bad thing, but we've reached that point where we are making the best effort I think we can under these circumstances. There is a sense of urgency here, but I always want to be very careful that when acting, because there is an urgent concern, we don't act in haste. And I believe that this amendment tries to thread that very narrow path, or thread that very narrow eye of the needle. So thank you. I just want to say that.
Thank you. I know that it was a lot of compromise. I'm personally very satisfied with where we've come down on it. And I'm delighted that the author and others were able to make this into what may be a Bradley special, where nobody's thrilled, but we're going to go with the good in reference to the perfect.
Madam Chair?
Yes, Senator LeVay.
Yes, I just wanted to say that I'm much more pleased with this amendment. I think that it was interesting to hear that the banks were using such good best practices. And the problem is not them, it's the exception that is not looking out for our people. And I think that we have to remember that we are in a different time right now. There's going to be a lot of people that are going to be in a position where it's going to be difficult to pay the rent. They're getting up on their feet. Rent increases may not be something that they could handle readily. So having a notice is important. And I'm reading a book about leadership during challenging times. And I love this book because I learned about things like Social Security and how people thought we would never have it. And then we got it. And I feel like we're in one of those times when we need to do things a little bit differently because our country is going through crisis. So I appreciate this amendment and addressing some of the concerns of housing. Thank you.
Thank you. Any other comments before we vote on the amendment? Then I will take the roll call, what we're voting on now. So that I'm sure I know what we're voting on. We are voting on the amendment 1433S. And I would like to call on Senator Chandley. Yes. Senator LeVay.
Yes.
Senator Carson.
No.
Senator French.
No.
And I will vote yes. So the vote is 3-2. And now I need to vote on the bill with the amendment. Is that correct? So do we have a motion on for the bill with as amended?
I move ITL.
Oh, sorry, Senator French, we already have a pending motion on the bill.
Oh, that's right. We do. We do. We already have that. That's why we did it first. So you couldn't do that.
That was
No,
smart.
I'm just kidding. Okay, so we have a pending motion, but we can have a discussion at this point before we vote. Would you like to discuss, Senator French?
No, I'm just disgusted.
Oh,
Is that a pun?
That was.
It's been a long day.
That's like past tense
Senator
of
French is
disgust.
known for being a straight shooter, so.
That's right. That's right.
Yeah.
He likes his straight shooting. So don't get me giddy. Okay, so what any other discussion except for Senator French? Seeing none. I would like to call the roll on Senate Bill 1247 as amended, and I would like to start with Senator Chandley.
Yes.
Senator LeVay.
Yes.
Senator Carson.
No.
Senator French.
No.
And I will vote yes. So it has passed 3-2. And at this point, I would like to.
Sorry, Senator, who's taking that one out?
Oh, I'm sorry. That's a good, oh, how about Senator Chandley taking that one
How
out?
about Senator French?
Because he voted no.
I'm just kidding. Getting punchy.
I had him listed as on my notes but he said no, so now we can't do
Oh,
it.
so now I'm being punished.
Well, I'm afraid of what you'll say.
That's true.
Are you willing, Senator Chandley?
Yes.
You also have misgivings, so if you don't want to, I can do it.
No, I'll do it.
Okay. What I would like to do at this point is to give enormous thanks to our staff, the people who have made this all possible, who made us be razzle dazzle, etc. And that includes Jenny, of course, who's gotten us through an amazing last 2 years. Ava, who just makes us all smile with her charm and her grace and her smile. Bobby Collins, are you still? Yes, you are still here. I hardly recognized you. Cameron, you are fabulous. Thank you so much for being our interrupter today. Alan Raff, oh my goodness.
Yay, Alan.
Woo! Greg Silverman, who is the brains behind all of us, and Sarah Persitino, who has, without any question, had the most grief through this entire process. Thank you so much to all of you. And we will be meeting again, I guess, about another bill. Is that right?
Okay.
I thought we were going to be done, but so it's not my last hearing, but it's close to it. So be nice to me.
I've hired Cameron to bake you cookies for the last one.
Full cookies would be good. Yeah. My husband, just in the interest of full disclosure, brought me a little sherry. So I'm doing okay.
Nice, nice.
Okay. So we need somebody to take us out of executive function. Executive
So
function.
moved, Madam Chair.
Executive session.
Second.
Thank you. Senator Carson is moved out of executive session and seconded by Senator Chandley. Roll call vote will be Senator Chandley.
Yes.
Senator LaVake.
Yes.
Senator Carson.
Yes.
And Senator French. Where are you? Oh, there you left.
Yes.
And I will also vote yes, so we go out of executive function with huge thanks to everybody on this Zoom call. Thank you, Senators.
Thank you.
Thank you.
Bye.
Thank you, everybody.
Bye.
Bye, Senator French. Bye, Senator
Bye.
Carson. Have a good
Bye,
weekend.
everybody.
Yep, you too.